Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to continue the saga of the case of the Queen and Richard Sr. Now, if you haven't been following along, I did a bunch of videos on this previously, but what happened is Richard Sr. is a former police officer, and they suspected that he was taking police data and sharing it with people involved in criminal activity. They also ended up finding out that he was involved in ticket fixing, so that took down a Crown prosecutor as well. I did a video about that. But as a result of all of this and their suspicion, they started up a big undercover operation in order to see what was going on. And in the course of this, it escalated from, is he misusing police databases onto him stealing a shotgun from the police and having a grand plan to rob some drug locker and sell cocaine to this drug figure who was actually an undercover police officer. So the facts are pretty wild, and I'm not going to go through all of them again because lots of videos that covered it. Now, I just want to get through, I'm hoping, the entrapment decision, because that came out in November. I've been owing you guys a video on that for some time, but it's 158 pages, so I'm not going to go over the facts in huge detail here. I'm going to try to get through this in one sort of digestible video. So let's have a look at, and again, this is the decision on entrapment. So Mr. Senior was found guilty of a number of these offenses, and entrapment is actually this weird sort of defense where it's not really a defense to say that you're not guilty of it. It's to say, listen, notwithstanding that I've already been found guilty of this, you shouldn't go ahead and convict and punish me because this was abusive state conduct. So an entrapment argument actually happens after you've already been found guilty of the offense. And let's have a look at, we'll see a little bit more. This is actually a really good case for looking at the entrapment law because it's very thorough. All right, so there's also a publication ban on the identities of the people known as UC1, so Undercover 1 and Undercover 2. In this case, Undercover 1 is usually just referred to as UC1. That's the partner of the of Mr. Senior, so he's pretending to be, he's actually a police officer, but he's pretending to be the partner of Mr. Senior. UC2 is under the pseudonym of Henry Wong, and he was pretending to be this organized crime figure who's, it's this long and sordid tale, but basically he was acting as an informant to the police, and in so doing, he was bolstering Mr. Senior's career because now he's getting all of this good information, and the whole thing is really the snake eating its tail because none of this is true. So I hope that made even a little bit of sense because this case is weird. All right, so ruling on entrapment application. The applicant, Richard Sr., a constable with the York Regional Police, at the relevant time assigned to the 5-District Community-Oriented Response Unit, 5 Corps, in Markham, was charged with 14 separate offenses, including theft under $5,000, uttering a forged document, 2 counts, unauthorized use of a computer, 2 counts, breach of trust, 3 counts, possession of firearm obtained by theft, possession of weapon for a dangerous purpose, attempted robbery, trafficking in a Schedule 1 substance, and trafficking in a Schedule 4 substance, 2 counts. The charges were in relation to allegations stemming from a YRP suspected police corruption investigation known as Project Hadot, which involved the deployment of 2 undercover officers, UC1 and UC2, operating under the pseudonym of Henry Wong. By the relevant time frame, Constable Senior had been a police officer for approximately 15 years, with a focus on traffic enforcement for much of his career. They're going to make a big deal about the 15 years thing. That's going to come up many times as we go through. So I'm skipping over a bunch of things here, and that's going to continue. I'm going to link the full decision below so you can check it out and read it. As I said, it's 158 pages, so I'm going to try to get through this as quickly as we can. Given that this entrapment application was anticipated as a possibility at the time of the trial, much of the cross-examination of UC1 and UC2 at trial was not relevant to Constable Senior's guilt or innocence, but rather focused on this application. It is agreed that the evidence from the trial can be applied to this application. So normally, by strict formalism, you'd need to have a separate sort of process of calling evidence on the entrapment application. But nobody really wants to waste that much court time. Nobody wants to have an inefficient process. So you might insist on the strict formalism if there was a reason for it, but here it sounds like defense counsel and the Crown probably said, listen, We know that the entrapment is really the big deal on this trial, so why don't you just ask your entrapment questions at the trial, and then we'll have the entrapment application using that evidence. Saves us all a bunch of time, saves both Mr. Senior and the taxpayer a bunch of money, so good on both of them. All right, continuing on here. On this application, the applicant submitted that, on a balance of probabilities, the actions of the YRP, specifically Undercover 1, Undercover 2, and Detective Sergeant Salia during the Project Tado investigation constitute improper virtue testing amounting to entrapment. The applicant conceded that, as per the first branch of the test in the Queen and Mac, the police had reasonable suspicion that Constable Senior was committing the offenses of breach of trust and unauthorized use of a computer early in the investigation. However, the applicant submitted that the police did not have reasonable suspicion that Constable Senior was engaged in the particular criminal activity involved in counts 1 to 3, 6, 7, 9, and 12, and any suspicion that Constable Senior was committing these offenses was inextricably linked to the influence that the undercover operators had over Constable Senior and the directions they were given by the investigative team. Consequently, as it relates to counts 1 through 7, 9, and 12, the police acted beyond the bounds of propriety, induced the commission of the offenses, and therefore the only appropriate remedy is a stay of proceedings in relation to these counts. Now, if you're wondering what is a stay of proceedings, it means that the judge says, listen, this can't go any further. The trial is over. We're not going to come to any further decision. It stops. And for Constable Senior, that's as good as an acquittal. It means that it's not a finding of guilt ultimately, or not an entry of a conviction, and so it's a very good result for Constable Senior. People get very upset about stays of proceedings, but they are an important tool in order to ensure charter rights are protected, and other things in terms of stays of proceedings are used sometimes for abuse of process or other such things. So it is an important judicial tool. So further, the applicant submitted that the police conduct during the Project Tado investigation was so egregious that it justifies the exercise of this court's residual discretion in ordering a stay of proceedings for abuse of process in accordance with the test set out by the Supreme Court in the Queen and Babos. So the respondent submitted that, as the scenario with UC2 played out, the everyday interactions between UC1, who's the fake partner, and Constable Senior, and the information gathered via the authorized Part 6 revealed new and unexpected ways in which Constable Senior was abusing his position as a police officer. Now, just as a note here, the applicant and the respondent here is it's legal language. Applicant is the person who is bringing the application that is being looked at, and the respondent is the person who is sort of receiving that application and fighting against it. So in this case, the applicant is Constable Senior and his counsel. They're the ones bringing the application to have everything thrown out on the basis of entrapment. The respondent is the Crown. So just to clear that up. So the respondent submitted that the investigators' suspicions and beliefs, as well as their instructions to UC1, evolved in reasonable and justifiable response to these unexpected developments. On September 12, 2018, upon Constable Senior sharing the license plate information with Henry Wong, the investigators believed their work was over and took steps to disengage. However, before any arrest could be made, the respondent argued that on September 17, 2018, Constable Senior proposed to UC1 that they rob a drug warehouse. At this point, investigators directed UC1 to continue the relationship in order to assess whether Constable Senior was serious and to see how far the plans would progress before a takedown was necessary. The respondent submitted that the intercepted communications and evidence gathered demonstrates the initiative, determination, and volitional choice of Constable Senior, a 15-year veteran of the police force, to engage in the criminality for which he was found guilty. The respondent argued that Constable Senior has failed to meet his onus to demonstrate that he was entrapped, or that the investigative conduct more generally constituted an abusive process. Therefore, the application should be dismissed. So those are the positions of the respective sides here. Now the justice is going to go through the law of entrapment. So that'll help us understand more what tests the court is applying here. Because we can't just say, hey, these are the facts. We have to apply those facts to particular legal tests. That's kind of how the law works. Is, what happened, and then what are the rules that say how that should work? If you think about this in terms of, and I'm gonna probably mangle this because I am not a sports fan, but if you think about it in terms of, say, hockey, the puck went into the net. Okay, what do the rules say that mean? Okay, that tells us that they've scored a goal. Or, you have to apply the rules to the facts. Without the rules that say that a puck going into the net is significant in some fashion, you don't care that it happens. Same with the law. I probably mangled that, but let's keep going here. So, law of entrapment, the rationale. So, they're going to talk a little bit here about why we have entrapment law. Because lots of people say, listen, he did crimes. So, why are we bothering to ask what the police did? Shouldn't we just skip that and send him directly to jail? Well, they're going to explain why we do this. So, entrapment is not a true defense. It is a type of abusive process. It protects accused persons from criminal sanction where they have been unfairly led by the state into committing offenses. And they are quoting the case of the Queen and Gotra. The defense of entrapment flows from the doctrine of abusive process. It is not a substantive defense to allegations of criminal wrongdoing, but instead allows for a conviction to be stayed where the investigative conduct of the police was exploitative or corrupting. So, as I said before, it isn't something to say I didn't do it or it wasn't my fault. It's something instead to say, listen, I may have done it, but you still shouldn't punish me because this is unfair based on what the state has done. So it's an important distinction between things like a defense of self-defense, which is to say, I may have done the actions, but it's not illegal because I was justified. That's not what entrapment is about. So where entrapment is raised, the question is not one of guilt or innocence, but rather whether the accused's guilt was discovered in a way that offends the principles of decency and fair play. Accordingly, entrapment is raised after a finding of guilt, but before a conviction has been entered. And I'm going to skip over a bunch here just because, again, time frames. There's a crucial distinction, one which is not easy to draw, however, between the police or their agents acting on reasonable suspicion or in the course of a bona fide inquiry, providing an opportunity to a person to commit a crime, and the state actually creating a crime for the purpose of prosecution. The former is completely acceptable, as is police conduct that is directed only at obtaining evidence of a crime, of an offense when committed. The concern is rather with law enforcement techniques that involve conduct that the citizenry cannot tolerate. In many cases, the particular facts may constitute a classic example of what may be referred to as entrapment, which has been described by an American judge as the conception and planning of an offense by an officer, and his procurement of its commission by one who would not have perpetrated it, except for the trickery, persuasion, or fraud of the officer. So if you want to think of some of the most egregious examples of entrapment, might be, for instance, going and convincing somebody that, that they're going to come to harm unless they, do this, or the police harassing them into committing an offense. But we do allow for some investigative techniques that people sort of tend to think as near entrapment. So, for instance, bait cars, where the police set out a car that they expect is going to be robbed or going to be stolen in an area where there's high crime, and they've got it rigged up in various ways, with GPS or cameras or sometimes fancier things, and saying, okay, well, now we're going to see if somebody decides to break into it. There's sort of a difference there in terms of how this is going. But, you can't sort of basically troll just to see who might commit a crime out there. You don't want the police manufacturing offenses is kind of the idea. So skipping over a whole lot here, because again, this is a lot of theory. But essentially, one thing I'll sort of stop. A lot of people typically describe things as Orwellian, or they'll say it's like 1984. And a lot of the time when people say that, it's fairly clear that maybe they didn't read the book. But when you actually break the book down, 1984, and, it's about a scenario of a police investigation, sort of, a secret police investigation. You've got your main character there who, at the outset of the book, is committing crimes relative to his society, which of course should not be crimes, but he's living in an oppressive society. But they don't stop there. They don't say, oh, well, we're just going to wind this up and that's it. They want to make sure that they have him on some bigger stuff so that they can make more of a show of arresting him. So they provide him with additional opportunities to commit larger crimes by providing him with, what he thinks is a private space, which isn't of itself in that weird society that Orwell, envisioned, is itself a crime, but also provides for him to, act out in further ways. Again, part of why this is all shocking is that a lot, all of the acts that they punish him for are ones that we would consider innocent and laudable in the larger scenario there. But ultimately, they sort of ensnare him in much more than that by this operation. So when we're talking about entrapment, it's worth considering that 1984 is really a book, there's larger concepts, of course, but if you get down to the very literal sense, it's about an entrapping style police investigation. And 1984 would probably not count as entrapment. That is probably a whole video in and of itself. So anyway, let's carry on. So the test. The onus to demonstrate, so the onus is the burden. Who has the job of proving a particular thing? So the onus to demonstrate that entrapment has occurred is on the accused to establish on a balance of probabilities, which means more likely than not. So the accused has to tip the scale up to it's more likely that entrapment happened than that it wasn't. This is the kind of thing that the average person doesn't think is very important, but the onus is huge. Who has the burden of proving something? Cases are won and lost on who has the burden of proof. So, and cases are overturned at appeal based on, the courts getting that wrong. So that is actually a really important line. The Supreme Court of Canada in the Queen and Mac and the Queen and Barnes established that entrapment will arise in one of two distinct ways. First, the authorities provide a person with an opportunity to commit an offense without acting on a reasonable suspicion that this person is already engaged in criminal activity or pursuant to a bona fide inquiry, so opportunity-based entrapment. Or, although having such a reasonable suspicion or acting in the course of a bona fide inquiry, they go beyond providing an opportunity and induce the commission of an offense. So, as an example here is, the opportunity to commit an offense. So let's say I go up to a random person, like if I'm a police officer and I go up to a random person and there's no reason to believe that this person is in any way involved in criminal activity. And I say, hey, I have this package of cocaine. Can you please run it across town and deliver it to this particular location, which would be drug trafficking. And for this, I will pay you $1,000 now, and there's another $1,000 waiting for you when you deliver it. And I just go up to this random person and say, here's how you can make $2,000. All you got to do is run this package across town. Well, lots of people are going to be tempted by that, but there's no sign that they were doing anything. It's just they happened to be walking down the street and somebody says, hey, do you want $2,000? Lots of people would be tempted by that. So the courts say you can't do that. Or the other one is having a reasonable suspicion, they go beyond and induce it. So let's say the police have all sorts of reasons to think that Bob is a drug mule, that Bob's, income is derived entirely from driving drugs from one town to the next. And so they get an undercover, that undercover befriends Bob and says, hey, I got some stuff that I need moved and I need it moved, secretly. Don't open these packages. I'm being real suspicious about all what I'm doing, and I'll pay you $10,000. I need you to move this, box over to, from Edmonton to Toronto. And Bob says, get bent. Not doing it. But you keep at him and you harass him and you bother him and you maybe get threatening about it. You say, oh, well, the last guy who said no to me, things didn't end up so well for him. And eventually Bob says, you know what? Fine, I'll do it. Now we're talking, maybe inducement. We're pressuring this guy who didn't want to commit the offense into committing the offense. All right, carrying on. Queen and Barnes, the court clarified the first branch as follows. Random virtue testing, conversely, only arises when a police officer presents a person with the opportunity to commit an offense without a reasonable suspicion that A, the person is already engaged in the particular criminal activity, or B, the physical location with which the person is associated is a place at which the particular criminal activity is likely occurring. Now, I want to stop there and just think about this one a little bit, because I mean, the person, if we're talking about a specific person because of, we're talking, Bob specifically, maybe that's not such a concern. But if we're talking about a person who just looks kind of sketchy, that's its own problem. But the physical location, well, where do crimes tend to happen? Well, more, they tend to be associated with poverty, and which means that you'll get sort of hot spots where people are poor and desperate. And, if we're talking about random virtue testing and it's okay at a location where, high criminal activity is happening, it basically kind of seems to forgive random virtue testing so long as it's aimed at the poor and marginalized. We can't do this at the nice area of town because it's relatively low crime and, but if you go into the poor areas, and let's be honest, we have a society with a whole bunch of racial problems, so these are often, racialized areas as well. Then you can go test people. And if you think about it in terms of, presenting people with this opportunity to commit an offense for personal gain, targeting the poor is kind of crappy, right? I kind of feel like if somebody is really desperate to make rent and suddenly, the police leave them with this opportunity to make $1,000 for some small crime. Lots of people, if they're desperate to not get, tossed out on the street, might be tempted to do that if $1,000 is a lot of money to them. But if $1,000 isn't much money to them, then your virtue is unlikely to be challenged by this. So I kind of have a problem with this conception of random virtue testing because it really seems to forgive or allow for some random virtue testing in ways that I find concerning. So I'm just going to leave that there. That's just kind of my thoughts here. All right, carrying on here. So Constable Senior has alleged both opportunity-based and inducement-based entrapment. And the defense of entrapment can only be established in the clearest of cases. Now, clearest of cases is basically court language to say we really don't like issuing stays of proceedings in court cases. It's considered sort of the remedy of last resort. So, because there might not have been an offense to prosecute without the entrapment, the conviction for that crime is inappropriate. For this reason, Lemur said unequivocally for the court in Mack, the proper remedy is a stay of proceedings. The trial judge was correct in recognizing that. In this case, the parties agree that the appropriate remedy, if entrapment is established, would be a stay of proceedings. So, Crown and defense agree on this because this is just the law. Like, this is way settled, so this is not an issue that is being argued by either side. Reasonable suspicion. The starting point for determining whether entrapment occurred on the first branch of the Mack test requires an assessment of whether reasonable suspicion existed at the relevant time. And they say since this case is focused on the suspicion that in relation to the individual rather than a location, the court will focus its analysis on that issue. So, notwithstanding the fact that I brought up the whole location aspect, that'll have to be something we explore further in another video. And so I'm going to skip over a whole lot of discussion here again, just for time. So reasonable suspicion is not an unduly onerous standard. It's actually a fairly low standard, believe it or not. So reasonable suspicion is defined as something more than a hunch, feeling, expectation, or mere suspicion, and something less than reasonable and probable grounds. So, more than a hunch, feeling, expectation, or mere suspicion. That doesn't sound like a lot, right? More than just you made it up. The fact that reasonable suspicion deals with possibilities rather than probabilities necessarily means that in some cases the police will reasonably suspect that innocent people are involved in crime. So, if the police get this wrong, they're allowed to try to entrap you, or they're allowed to, present you with opportunities to commit crime that otherwise they would not necessarily be able to. So, if you happen to look like people who are committing crimes, like, say, because you happen to be dressed in a particular fashion, or, yeah, then that may allow the police to do, to make those inquiries where otherwise they couldn't. So, as a guy who might be, dressed nicely, out and about, I might enjoy greater legal protections than somebody dressed differently. That I I have problems with this whole method of analysis. Let's just leave it. Let's just go with that. Uh, so they say, indeed, the reasonable suspicion standard is designed to avoid indiscriminate and discriminatory searches. Do you think that? I kind of feel like the whole design of it actually doesn't do that. But carrying on. Further, reasonable suspicion need not be the only inference that can be drawn from a particular constellation of factors. Much as the 7 stars that form the Big Dipper have been interpreted as a bear, a saucepan, and a plow, factors that give rise to a reasonable suspicion may also support completely innocent explanations. This is acceptable, as the reasonable suspicion standard addresses the possibility of uncovering criminality and not a probability of doing so. Exculpatory, neutral, or equivocal information cannot be disregarded when assessing a constellation of factors. The totality of the circumstances, including favorable and unfavorable factors, must be weighed in the course of arriving at any conclusion regarding reasonable suspicion. And from Golub, the courts found the officer must take into account all information available to him and is entitled to disregard only information which he has good reason to believe is unreliable. This is self-evident. However, the obligation of the police to take all factors into account does not impose a duty to undertake further investigation to seek out exculpatory factors or rule out possible innocent explanations. So they have to do no work on this. They don't have to investigate anything. They can just rely only on what actually lands in their lap. So finally, the objective facts must be indicative of the possibility of criminal behavior. While I agree with the appellant's submission that police must point to particularized conduct or particularized evidence of criminal activity in order to ground reasonable suspicion, I do not accept that the evidence must itself consist of unlawful behavior or must necessarily be evidence of a specific known criminal act. So the court is rejecting this notion that it has to be a specific crime in that sense. All right, so carrying on here, they say, an officer's training and experience may provide an objective, experiential, as opposed to empirical basis for grounding reasonable suspicion. However, this is not to say that hunches or intuition grounded in an officer's experience will suffice, or that deference is owed to a police officer's view of the circumstances based on her training or experience in the field. A police officer's educated guess must not supplant the rigorous and independent scrutiny demanded by the reasonable suspicion standard. Evidence as to the specific nature and extent of such experience and training is required so that the court may make an objective assessment of the probative link between the constellation of factors relied on by the police and criminality. The more general the constellation relied on by the police, the more there will be a need for specific evidence regarding police experience and training. To the extent that specific evidence of the investigating officer's experience and training supports the link that the Crown asked the court to draw, the more compelling that link will be. Now, I don't like this, and the reason why I don't like this is that an officer's training and experience may actually lead them to making bad decisions. And as an example of this, let us imagine that we have 10,000 people, and those 10,000 people are evenly divided in terms of what color hat they like to wear. You know, some like yellow hats, some like blue hats, some like green hats, and some like red hats. And those are, about evenly distributed. And let's say that it's also about evenly distributed through that population of 10,000 people, that they are committing a particular crime at any particular day. But let's say the police have the notion that people who wear green hats are associated with that crime. Well, what are they going to go do? They're going to go and focus their investigation on people wearing green hats. And as a result of that, they're going to discover more of that crime with the people wearing green hats, which reinforces that experience and training that green hats mean that particular crime. In fact, from the sort of factual basis I've set up here in my sort of example hypothetical, what color hat you wear means absolutely nothing. Just nothing, right? It's just a random association or random thing that you might be doing. But because that's where police investigation gets aimed, that's what police decide means that you're committing a particular crime. This can also be interesting in terms of what crimes police officers detect, because certain crimes are easier for police to find than others. So I would like to see actual empirical evidence, in terms of, we did studies, we dug into this, we looked into whether or not there's actually an association here. But the court's saying that's not necessary. So in the Queen and Ahmed, the Supreme Court of Canada looked at this a little further, and they said, people are not protected against random virtue testing if we assume that entrapment occurs only when virtuous people would be tempted to commit crimes. The opportunity-based branch of the MAC test therefore establishes that police cannot subject anyone to random virtue testing, virtuous or non-virtuous, predisposed or non-predisposed, without reasonable suspicion. And think about it, right? It's if we think about this as trying to tempt people to have a drink, a drink of alcohol, and you might say, okay, well, you're offering everyone the equal opportunity, and some people will take it and some people will not. But not everyone is necessarily equally predisposed. If you've got somebody who's a recovering alcoholic and you hand them a glass of vodka, they might be more tempted to drink it than your average person. But you shouldn't go up, if we assume that them drinking is a bad thing, you shouldn't go up and hand recovering alcoholics booze. And similarly, if you've got somebody who is, who used to deal drugs and has now gone and got a job and they're working as a roofer or, whatever else, just some random job, they're, just Joe average trying to go about their day. We don't want the police going up to those people and saying, hey, listen, here's an opportunity to make a whole pile of money by going back to, bad ways. It's, the test shouldn't just be, would a virtuous person, an honest, law-abiding person, a person who is free of temptation, be bullied into this? It should also be, are they maybe tempting people who are struggling, but doing okay? So I got a problem with that. I mean, I think if somebody is working real hard at rehabilitating themselves, I don't want the police coming in there and trying to, send them back to their old ways. I think that is a bad thing. Similarly, if you've got somebody who is tempted to do bad things but hasn't done any, I kind of feel like we don't need to give them a push into committing crimes. That's my feeling. So providing individuals with the opportunity to commit crimes commit offenses without the foundation of a reasonable suspicion also unacceptably increases the likelihood that people will commit crimes when they otherwise would not have. The risk is at its highest when the person given the opportunity is comparatively vulnerable or otherwise marginalized. Random virtue testing therefore violates the principle that it is wrong for the police to manufacture crime because it preys on the weaknesses of human nature to entice individuals into offending. Marginalized people with the limited resources they possess will rarely, if ever, be able to meet the high burden of proving bad faith. There will rarely be evidence of intentional racial profiling or targeting of the vulnerable. Conversely, the test in MAC, grounded in reasonable suspicion, is attainable for everyone, designed as it is to accommodate the qualities of humanness which all of us share. It seeks to protect the justice system and preserve the rule of law by ensuring that all individuals predisposed or not, are protected from improper police conduct. You know, it's sort of a famous thing of the rich and the poor are equal before the law because they're all banned from stealing bread and sleeping under bridges. But of course, if you're Elon Musk, you're probably not feeling a whole lot of inclination to steal bread or sleep under bridges. And so providing the opportunity to steal bread is only going to entrap, is only going to snare the hungry and not the wealthy because they have no need for it. So that's kind of what they're concerned about, is that a lot of this providing the opportunity to commit crimes is going to actually go after the people who are struggling most. And that's pretty awful. All right, skipping over a whole bunch more here. They say our point about timing is fundamental. Reasonable suspicion is not formed retroactively. Rather, it is applied prospectively. From its inception, the entrapment doctrine has required that police officers have reasonable suspicion of criminal activity before providing an opportunity to commit an offense. So this just makes some basic sense, right? Because you can't say, hey, listen, we left a wallet out, and then the person took the wallet, so therefore we have reasonable suspicion that they're the kind of person who would take a wallet because they did. It's no, you have to have that suspicion first. Otherwise, you're just, kind of baiting them. So the police are permitted to form reasonable suspicion through investigative steps, including investigative steps that involve direct contact with an undercover officer, as long as the requisite suspicion is present before the opportunity is provided. In the Queen and Ramelson, the court stated, in Ahmad, the tips the police had received about the dial-a-dope operations were of unknown reliability. The court had no trouble concluding the police, at the time they placed the call to the telephone number in the tip, did not have reasonable suspicion that the person who answered the phone was involved in drug trafficking. Hence, without reasonable suspicion, the police could not offer the person the chance to sell them drugs. So, they get a tip of dubious or unknown reliability that this phone number is associated with a dial-a-dope operation, where you call up the drug dealer and they deliver drugs to you. But the police can't say, hey, can you deliver drugs? Because this might just be some random dude's phone number, and you can't just bait some random dude in that fashion. Now, let's have a look at how this applies in practice, because this gets a little funny. So in the police conversation, Ahmed used drug culture jargon by responding, "What do you need?" This response gave rise to a reasonable suspicion he was engaging in drug trafficking, and the police could then offer to buy drugs from him. He was not entrapped. That's their decision for that guy. On the other hand, Mr. Williams' only responses before the police offered to buy drugs from him were, "Yeah? Who is this?" and "Vinny who?" These responses did not give rise to a reasonable suspicion he was engaged in drug trafficking. Therefore, he was entrapped. The difference here is, how did you answer the phone? And how many people knew that "what do you need" is drug culture jargon? That's... I am sure that somebody out there is answering their phones with "what do you need?" and they don't mean drugs. So you may not actually realize what things you do in average day that create reasonable suspicion that allow the police to just throw an opportunity to commit a crime at you. Are you feeling protected from the police here? Because maybe not. All right, carrying on here, they say, importantly, reasonable suspicion of a criminal activity does not permit the police to offer an opportunity to commit any and all criminal activity. There must be some connection between the criminal activity for which the police hold a reasonable suspicion and the criminal activity that is the subject of the opportunity to presented. So, continuing on here, just as an example of that is, like, let's say I see somebody, I'm a police officer again in this sort of imaginary hypothetical. I see somebody walking down the street and they're peering into cars, like into parked cars, as if they're looking for things to steal. And they're trying car door handles. And so I think that they're there looking for a car to steal. I can't walk up to them and say, hey, do you want to traffic AK-47s to terrorists? Because there's no indication that that's something they're involved in. That's me trying to fish for a much more interesting crime than what I think that they're doing, which is, cruising around for a break and enter. or for a break and enter into a vehicle there. But if I did want to, if I saw that, it wouldn't be improper for me to necessarily go a block up to where my car is parked, or where I've got a bait car parked, and chuck a wallet in there as a bit of bait, because I think that this person now is looking to commit a specific crime of breaking into cars, and now I'm giving them the opportunity, having formed the reasonable suspicion that that's what they're doing. So that's kind of a distinction in terms of the type of crime. So they say, there is no question that reasonable suspicion in relation to one particular criminal activity does not allow the police to provide the opportunity to commit any and all criminal activity. However, exact parity between reasonable suspicion and opportunity is not required. And they say, using the guidance, it is clear that the crime for which the police have reasonable suspicion and the crime that the police provide the accused with the opportunity to commit must be rationally connected. In other words, the reasonable suspicion crime and the opportunity crime must be causally linked, in the sense that suspicion of one leads rationally to providing the opportunity for the other. Proportional. So in other words, the opportunity provided should be no more than what is required in the circumstances to draw out the sought-after behavior. And temporally connected. The reasonable suspicion should be premised on events that are reasonably close in time to the related opportunity provided. So those are sort of guiding principles here. So opportunity. Not every police action will amount to providing an opportunity to commit an offense. In The Queen and Ahmed, the Supreme Court discussed the relationship between the police conduct and the commission of an offense to create an opportunity. And they stated a whole bunch of things, which I'm going to quote a little bit from, but again, you can read the full decision if that's what you feel like. So, for example, in Bayat, the justice there concluded that beginning an online conversation with a target was not an opportunity to commit the offense of child luring. He likened the first contact to a knock on the door. So, and they said an opportunity to commit an offense is offered when the officer says something to which the accused can commit an offense by simply answering yes. So that's a fairly narrow description of providing an opportunity. Because they don't want to define this as to capture all investigative conduct provided by the police. So, and one of the examples here was that they had an investigating officer posing as a child, and, just the sheer discussion or a sheer response to that doesn't necessarily indicate that, that they're committing an offense if they're just talking to a child. But if it happens to be, discussions with a child that have ventured into sexual topics and suggesting an in-person meeting, then, that might be undercover if it was the undercover officers suggesting that. But not if the accused is making that suggestion. Hopefully that doesn't annoy YouTube here. We'll see. So inducement. Where reasonable suspicion is present, the court then turns to the question of whether there was inducement as opposed to mere opportunity. The test is objective. So the courts must consider inducement through the lens of an average person in the accused position. In the case of Mack, the court stated, as regards the latter form of entrapment, to determine whether police conduct gives rise to this concern, it is useful to consider whether the conduct of the police would have induced the average person in the position of the accused, i.e. a person with both strengths and weaknesses, into committing the crime. They say the response to this is twofold. Sorry, I should back up here a little bit. They say, the state is involved in the question about the state being involved in the manufacture as opposed to the detection of crime. So that's kind of the concern that they're addressing this. They say the response to this is twofold. Firstly, I agree that there is a danger of convincing lambs, or people who have a particular vulnerability, such as a mental handicap, or who are suffering from an addiction. In those situations, it is desirable for the purposes of analysis to consider whether the conduct was likely to induce criminal conduct in those people who share the characteristic which appears to have been exploited by the police. And they say the nature of the relationship at hand, in terms of friends or acquaintances and so forth, is relevant, and in certain cases it may be that the police have exploited confidence and trust between people in such a manner as to offend the values society places on maintaining the dignity and privacy of interpersonal relationships. So that applies to all sorts of things in terms of friendships, but could also apply perhaps if the police officers were pretending to be a religious figure. That might offend society, or a lawyer. That, again, might offend society, or a doctor, that kind of issue. But also just, friendships. If you're talking about somebody who is a lonely person and this is the only time they're forming a friendship, and that friendship, it's, starting to become hinted that this friendship, that this is the only connection this person has in the universe, is contingent on them committing certain crimes, lots of lonely people could be baited into committing crimes in that fashion. They say, secondly, I do not find the danger of acquitting wolves particularly troublesome. It assumes that it cannot be said that the chance exists that a predisposed person would not have committed the particular offense were it not for the use of inducements that would have caused a non-predisposed person to commit the offense. More fundamentally, this perspective is part of a larger viewpoint that in certain cases it would be better for society to send someone to jail for committing a crime, even if fundamental rights and procedural guarantees normally provided to an accused have been disregarded. The familiar refrain is that the end justifies the means. Now, if you have looked at any legal scholarship in the history of ever, you know where this is going. So they say this view is, however, entirely inconsistent with the model of fairness which exists both within and alongside substantive criminal law doctrine. The typical line is that it's better for 10 guilty men to go free than that one should be sent to jail. So, yeah, they say, could not the same comment of acquitting wolves be made where an accused's right to counsel or to remain silent have been flagrantly violated and the evidence of his or her confession to the crime is excluded? They say in the short term, it may well be better for society to convict such persons, but it has always been held that in the long term, it would undermine the system itself. If the rule of law is to have any meaning and provide the security which all in society desire, it is axiomatic that it be extended to every individual. So again, part of the rationale behind the whole entrapment issue. So they go on here, they say the presence of reasonable suspicion or the mere existence of a bona fide inquiry will, however, never justify entrapment techniques. The police may not go beyond providing an opportunity, regardless of their perception of the accused's character and regardless of the existence of an honest inquiry. To determine whether the police have employed means which go further than providing an opportunity, it is useful to consider any or all of the following factors. So, again, this is when the police step beyond simply providing the opportunity to commit a crime where they have reasonable suspicion. This is when we're looking at when they do have reasonable suspicion, but they might be pushing somebody too hard. So they say, look at the type of crime being investigated and the availability of other techniques for the police detection of its commission, whether an average person with both strengths and weaknesses in the position of the accused would be induced into the commission of a crime, the persistence and number of attempts made by the police before the accused agreed to committing the offense, the type of inducement used by the police, including deceit, fraud, trickery, or reward, the timing of the police conduct, in particular, whether the police have instigated the offense or became involved in ongoing criminal activity, whether the police conduct involves an exploitation of human characteristics such as the emotions of compassion, sympathy, and friendship, whether the police appear to have exploited a particular vulnerability of a person, such as a mental handicap or a substance addiction, the proportionality between the police involvement as compared to the accused, including an assessment of the degree of harm caused or risked by the police as compared to the accused, and the commission of any illegal acts by the police themselves, the existence of any threats, implied or expressed, made to the accused by the police or their agents, and whether the police conduct is directed at undermining other constitutional values. The court made it clear that this list was not exhaustive, so these are examples of things the court can consider, but they can consider other things, like if the police come up with some new and different way to, cause problems, the court can consider that as well. They say any undercover operation will likely involve rapport building and storytelling. Whether that operation constitutes exploitation is a highly fact-specific inquiry. The question is whether the police have conducted themselves so as to offend the values society places on preserving the dignity and privacy of interpersonal relationships, considering those factors as set out in MAC. So, if the police manage to get an undercover officer placed within a criminal organization, there's going to be some rapport building, right? You don't get to be a member of, whatever street gang by everybody hating you. They've got to like you. There's got to be some rapport building. And you're going to be storytelling in the sense that you are lying about who you are. You don't get into whatever criminal, you don't join the mob by going, hi, I'm Joe. I'm an undercover officer, and I'm here because we really want to put all of you here in jail. That's my objectives today. So, can we hang out and commit some crimes together? Yeah, I mean, obviously not, right? So that's what the court is recognizing. They say simple persistence is not automatically inducement. In some contexts, a certain amount of pressure is to be expected. The fact that the police invest considerable amounts of time and resources into an undercover operation is not in itself exploitation or entrapment, but it may be relevant. So there is no dispute that the context for this entrapment analysis is that this is a police investigation of a police officer of nearly 15 years. The respondent argued that more leeway or a certain latitude should be granted in the investigation of police criminality because of this position of confidence occupied by the accused. And you know what? Ordinarily, I would say, yeah, the court disagrees. And I actually kind of think that the court made some good points here, although I didn't quote all of them. But they just say, although it is correct to account for the status of the accused as a police officer in establishing the factual context of the event, it is an error to elevate the standard of resistance expected of an accused police officer. And I mean, I said I skipped over a whole lot of this stuff, but basically they're not expecting, they say it is improper when applying the average person test to ascribe elevated standards of moral restraint or fortitude where a police officer is charged. And normally I would disagree with this, but honestly, the more I think about it, I think this is fair. Notwithstanding that I am something of a critic of police abuses, and I'm certainly not on the side, I don't want to see more police officers like Constable Senior. But this is criminal law. And I think that the higher standard that we should apply is possibly in terms of sentencing rather than in terms of guilt or innocence, or whether or not somebody should be able to avail themselves of something like entrapment. So I waffle on this one, but I kind of feel like the courts are right here, simply because this is the criminal law. And that everybody should be equal before the law, including police officers, as respect to, guilt or innocence and so forth. We shouldn't be saying that we're going to convict this person because they're a cop, whereas we would acquit them if they weren't. That seems unfair when I think about it. And that isn't the conclusion I had when I started this, but the more I thought about it, I was like, yeah. I don't think it's improper to consider his status as a police officer and the trust we place on police officers in terms of sentencing, but that's a separate thing. And I also don't think I have no problem with them applying a elevated standard of moral restraint or fortitude when we're talking about employment decisions. Because, I mean, another option that they had through all of this was just to fire him, right? They could have fired Constable Senior rather than doing this whole investigation. So let's carry on from there. So at this point in the decision, the justice goes through a very lengthy and detailed chronology of events. And I originally recorded some of that, and it worked out to be about 2 hours of content. So I've cut that just in the interests of time. Hopefully you've seen the previous videos which go over the sequence of events. And if not, you can either check those out or read the case in full in the description below. That said, I'll go through things really briefly. What happened here is that Constable Senior, there was a confidential informant who reported that he might be providing information from police databases to figures in organized crime. And so they decided to do a full audit of basically every search that he'd ever run. They narrowed it down to looking at when he ran names as opposed to license plates, because it was going to be easier to figure out if those were improper. They got about 14,000 queries that they went through, And they were cross-referencing this with his GPS data, with all of his reports, with his notebooks, all of this stuff. And they found about 150 queries out of that they thought were suspicious in some fashion. So because of that, they decided that they were going to launch this undercover operation. And so they planted this undercover operator number 1 as his sort of fake partner. They also set up this figure Henry Wong, which is, of course, not his real name, but this undercover police officer to be this fake confidential informant for Constable Senior. He thinks he's talking to somebody in organized crime, but it's actually an undercover police officer. They get warrants to tap his phone, to put audio recording in his vehicles, both his work vehicle, the police Tahoe, as well as his personal vehicle. And they, over time, they're sort of increasing the degree of rapport building and sort of worming their way deeper into his life. So, and eventually they get some information that suggests that he's involved in, more than that. So they start trying to get him on steroid trafficking. And eventually this whole plan comes to light about how they're going to steal a shotgun and rip off a drug locker. So everything goes a little crazy. And the real question is just how much this undercover officer is suggesting things to him. Now, I'm skipping out most of this sort of chronology, this background, because we're going to see it discussed again when they start analyzing the specific counts. So I'm trying to keep this as short as I can, and this summary is way shorter than the initial going through the case. All right, let's continue on here with some more from the case itself, as we're going to get to some of the meatier bits here. So context to this case. The applicant submitted that the entire investigation took a problematic turn towards entrapment with the introduction of undercover operators. This court does not agree that the introduction of undercover operators necessarily takes this investigation down a path towards entrapment. I kind of suspect that that wasn't the defense lawyer's argument. I suspect that it was in this particular case, but that's just a guess, personal. So, undercover officers are used frequently in police investigations. The involvement of undercover officers is often very necessary in police investigations. To suggest that this entire investigation took a problematic turn toward entrapment by involving undercover operators is wrong in this court's view. Yeah, as I said, I suspect that the defense lawyer's argument was probably that it was in this particular case that it was a problematic turn, because really they're looking at, is he conducting bad queries in the database? Surely the database queries, like that audit itself, would have been enough to get you what you need, or at least to the point where you could have said, hey, even if we can't prosecute this guy, we can just fire him. Like, I kind of wonder how much of this case comes about because of how difficult it is to fire police officers. Because, just fire him. Seems to me to be, a real easy and sort of short course here. But anyway, that's not what they do. The applicant goes further, however, to submit that the timing and incorporation of UC1 and his cover story is particularly troubling. It was submitted that UC1 was purposely placed at Constable Senior's side 2 weeks before UC2's deployment. From the initial deployment on June 27, 2018, to the first interaction between Constable Senior and UC2 on July 12, 2018, the most recurring objective given to UC1, so his fake partner, was to build rapport. The applicant submitted that UC1 did his best throughout this investigation to cozy up to Constable Senior. They worked together, drove together, ate meals together, went to the gym together, talked about their partners, affairs, kids, family, etc. The entire relationship, the applicant submitted, played on the importance of the buddy officer-partner dynamic and went a step further, the crooked buddy cop. UC1 regularly tried to convince Constable Senior that they were a band of brothers. UC1 did not observe any misconduct or criminality from Constable Senior in the first 9 weeks. It's a long time. And think about just how much taxpayer money is going to this, because they had a team who did this audit of basically every query that Constable Senior had ever run on his computers. Went back to 2006, I think they said. And, now keep in mind that the relationship between partners, like police partners, is a very unusual one. It's not like your average coworker, because you're actually relying on this person potentially to be the person who saves your life. If you get shot, they're the person who's calling for medical assistance or protecting you when they're the guy who quite literally has your back. So it's not really, it's not like another colleague at, a law firm, or, the guy who works next to you at the Wendy's or something. The guy who works next to you at the Wendy's, you might be friends, but it's not the same thing. So, and 9 weeks is a long time to be watching a person, right? So, regardless, he continued to paint the picture of being dirty and did everything he could to make sure Constable Senior trusted him implicitly before ever providing an opportunity for the commission of any offense. So he gets real close and real into his life. With respect to UC2, the applicant submitted that UC2's cover story, as a mid-level Asian organized crime figure involved in the importation of cocaine from China, was purposely constructed to leave the door open to investigate Constable Senior for offenses above and beyond breach of trust and unauthorized use of a computer, offenses that could be suggested by his partner. In his rapport-building interactions with Constable Senior, as heard in the intercepts, Henry regularly referred to the drug trade, the amount of money he made, and wanting to develop a good working relationship with Constable Senior. The applicant submitted that Constable Senior was faced with this information on one side, and on the other side, UC1 regularly reminded Constable Senior of his financial woes and his willingness to break the rules. So, there is no question that the two undercover officers, at the direction of Detective Sergeant Salia, had the goal of building rapport with Constable Senior. The undercover officers played the role of Constable Senior's friend and confidant. UC1 did, at times, provide Constable Senior with advice or guidance in the context of policing. However, it is of note that Constable Senior returned the favor to UC1 on occasions in areas where he had more knowledge or experience. From the many hours of intercepts, while Constable Senior does jokingly refer to UC1 as his coach on occasion, it is clear that these two officers were operating on an even playing field in their interactions with one another. There is no evidence that Constable Senior felt intimidated, pressured, or outranked by UC1. But when we looked at the previous videos, it is pretty clear that Constable Senior didn't know what he was doing with respect to undercover handling, and that was the particular area where he was leaning on UC1. So, I mean, if he's providing, additional information on, like, traffic stops or something like that, Anyway, those are the findings of the court, and it is what it is. But these are kind of my thoughts as I read through this case. As for the effect the undercover officers had upon Constable Senior, it is the view of this court that this is overstated by the applicant. Several things must be remembered. At the time of this investigation, Constable Senior was an officer with nearly 15 years of experience similar to that of UC1. Constable Senior and UC1 were at the same rank, both constables, meaning he had no authority to direct or give orders to Constable Senior. Again, that would have been intentional. They're specifically placing him at that rank so that this is not an argument that can be made later. Constable Senior had received standard police training, including 6 months in the Criminal Investigation Bureau. In the many hours of intercepted communications, Constable Senior demonstrated to be a knowledgeable police officer in many areas. I would hope so after 15 years. Constable Seniors and UC1 sought advice and guidance from one another on various topics, as one would expect of partners working together in any field. Constable Senior did not present as a vulnerable target. The many hours of intercepts show him to be a person willing to speak his mind and express his views and opinions. So, skipping ahead a little bit here, long before Project Godot commenced, Constable Senior ran some queries for friends and/or associates. And so there's other instances of, where he'd run checks for friends. She wanted him to run her name and her ex-boyfriend's name. I suspect that this kind of thing happens way too often. I suspect that the public would probably be upset if they learned just how many times queries are made that have nothing to do with policing, but that's its own thing. Checks of Danny Ian Doley, various other things. So skipping over some of this just for time. While this court certainly agrees that context is essential to a determination of this entrapment application, based on the totality of the circumstances, this court does not accept the view of that context as presented by the applicant. So this is already not looking good for Constable Senior because, yeah. All right, so now they're going through and looking at some specific counts. We will skip ahead here a fair bit just because there's a lot of stuff here. So they're going through some recordings, and they say, at the end of the recording, UC1 was leaving the station. UC1 never told Constable Senior that a police officer could not be a confidential informant. So this is with regards to, again, if you haven't watched the previous videos, Constable Senior has been involved in a messy breakup. And that messy breakup starts, he's got 2 affairs on the go, and he sends everybody he's involved with some pornographic video. It's not really clear what this video entails. The case doesn't detail that, but as a result of sending this, it ticks off all of these people, and the women he's having an affair with basically are like, yeah, we're telling your wife. So everything falls apart. But because of this, he's got a bit of a grudge against one of these women. And so he gets talked into, making a report about one of those women and, the fact or the allegation, the suggestion that she is involved in some criminal activity. So, at the end of the recording, UC1 was leaving the station. UC1 never told Constable Senior that a police officer could not be a confidential informant. He also never told Constable Senior that there would need to be a confidential informant background form, but UC1 testified, I think he knew from the first one. UC1 stated that he knew the source of the wafer information was Constable Senior, and that Constable Senior did not want his involvement known. According to UC1, if he himself wanted to share this information, he would send it in an email and document it in his notes. So UC1 has convinced him to make this application and basically to leave it out of his, leave out that he is the source of it. In his examination in chief, UC1 explained that by a few ideas, he meant in relation to confidentiality for Constable Senior in providing information on the intelligence report. He did not provide Constable Senior with any ideas at that time. In cross-examination, UC1 explained that this intelligence report would not have been disclosed to Sherry Wafer. UC1 also explained that Constable Senior did not need to bring the information forward. UC1 never told Constable Senior that this information could not be submitted on an intelligence report without a source. As confirmed by UC1 and Detective Sergeant Salia, there was no suspicion at that time that Constable Senior was falsifying confidential informant reports. So this is a new offense that they're just... And the way they did this, UC1 very much suggests to him that this is an idea. And then when he starts freaking out and going, hey, I'm being told I need to put a name down on it, that's when UC1 just kind of goes radio silent and stops being helpful. So skipping ahead again, just because we want to keep this at a manageable time frame here. Hopefully I'm hoping I can sort of thread the needle here in terms of content versus timing versus understandability. So let me know in the comments below if you're following along here. So now we're going to look at analysis and conclusion in relation to this uttering forged document for the Sherry Wafer report. So they say, there is no doubt that Constable Senior was the source of the information contained in the intelligence report. The information did not come from a confidential human source. Constable Senior did not even have the name of a source in mind at the time he authored the report, as evidenced by the communication between Constable Senior and UC1. Later on, he puts a specific person's name there because he's kind of backed into a corner and they keep saying, who's the name? Where's the name? You got to put a name on this. So further, as early as June 25th, 2018, there was reasonable suspicion in relation to obstruct justice, a separate offense that investigators also reasonably believed Constable Senior was committing with Caterina Petrollo during this period. That was with regards to some ticket fixing stuff. This court, however, does not see uttering a forged document as rationally connected to any of the earlier suspicions. There is no causal link such that suspicion of one led rationally to providing the opportunity for the other. Remember how they said that there's got to be a causal link there, and they're saying, no, not found here. The pivotal question, however, is whether an opportunity was provided, or did Constable Senior initiate these events? While it is true that UC1 made the suggestion to drop a dime on her, it appeared that Constable Senior had already come to this conclusion on his own. He had already decided to report Sherry Wafer and her family to police. The reality is that there was absolutely nothing wrong with Constable Senior reporting Sherry Wafer and her family, given the information available to him. There's absolutely nothing to suggest that Constable Senior was making up false information. In fact, information provided was ultimately considered legitimate to police, to the point that charges were laid. It is kind of interesting that one wonders here what they would have done if he hadn't been ensnared in this investigation and had just said, hey, I was dating this woman for a long time and I didn't tell you before, but it turns out that she's involved in drug production. But now that we're breaking up, I totally will tell you this. Like, isn't that kind of its own problem? I don't think that the police or the York Regional Police, I think it is, come out looking very well in this particular case. So I guess maybe I should avoid that particular area in my travel plans going forward in case they see this video. Anyway, from the very beginning conversations, Constable Senior was absolutely clear that he did not wish to be named as the source of the information. UC1 was well aware of that. On the very day these conversations began between UC1 and Constable Senior, UC1 stated, I have a few ideas to insulate you. Clearly, UC1 was aware of Constable Senior's wish to remain anonymous as the source and indicated he had some ideas to ensure that would occur. Constable Senior clearly chose the narrative voice for this report before any collaboration with UC1. So he's deciding how to write the report on his own. So when UC1 joined Constable Senior, he carried on in assisting him to complete the information on this form. On that very day, as the two of them were completing the report together, Constable Senior asked if he needed to provide a name in relation to the confidential human source, to which UC1 explicitly stated, no, it's just write what you see, write like what you smell, and we'll talk about fucking the anonymity of the source. The report was ultimately finalized by both officers on August 21st, 2018. UC1 then requested for Constable Senior to send the report to Detective Sergeant Bedford, which he did. So you can see that UC1 tells him to leave the name blank, and then that's what gets him in this difficult bind where he's now submitted a form where they're going to expect him to come up with a name. So the officers then, pressure him and basically say, hey, where's the name? Where's this name? You got to put a name down on this. And this was it was done by Detective Sergeant Bedford, but that was at the direction of Detective Sergeant Salia, who was running this whole thing. He says, hey, make sure you get this name, make sure you keep at him. So Constable Senior alone selected David Broadhead as the person to whom he would attribute the information. He completed and submitted the YRP 257 to include that falsehood. This court agrees that Constable Senior was not faced with an impossible choice. If he later realized that he used the wrong form and simply wanted to report the information, he could have simply advised Detective Sergeant Bedford of his error and sent an email with the information contained, which he'd done in 2012 with DC Fiore. I'm not sure, the rank there is just not coming to mind, but however, it is the view of this court that this is not the proper way to consider the entrapment argument. The fact that Constable Senior should have simply chosen the right path is irrelevant on this entrapment application, because again, we're not trying to limit entrapment to the point where it only is useful by the most virtuous, sainted individuals, right? We don't want the police entrapping both the good, but also, the bad who just wouldn't have committed the offense on their own. So that's kind of the concern here. This could be said in the context of any entrapment application. By the time an entrapment application is made, the person has already been found guilty. Certainly, the person who committed the crime should have simply chosen not to partake in the activity. If this were the test, entrapment would be impossible to demonstrate, And in some jurisdictions, that pretty much is the test, and it means entrapment is effectively dead law in those areas. But that's not how they're working it here. So that is precisely why entrapment is not dependent upon culpability and not focused on the effect of the police conduct on the accused state of mind, but rather on the conduct of state actors. While Constable Senior had clearly expressed the wish to remain anonymous, it was UC1 who said he had ways to insulate him and that they would discuss the anonymity of the source. There was no evidence that Constable Senior intended to add a name to the intel report or to attribute the report to David Broadhead before being urged to do so repeatedly by Detective Sergeant Bedford. When the report was submitted, UC1 had explicitly told Constable Senior that he did not have a name to put on, did not have to put a name, and assisted him in drafting the report so as to try to avoid the information being attributed to him. So he's actually helping him into the trap. UC1 was given the explicit daily objective from August 14th, 2018 to August 23rd, 2018 to encourage Constable Senior to complete the intelligence report. UC1 advised Constable Senior to start the intel report, sat with Constable Senior while Constable Senior typed into the report, assisted him in drafting portions of the report himself, reviewed Constable Senior's work, and encouraged him to submit the report to Detective Sergeant Bedford. This court does not agree that Constable Senior initiated and maintained the primary role in the completion and the submission of the false form. Further, Detective Sergeant Salia agreed that the back-and-forth email exchange between Constable Senior and Detective Sergeant Bedford from August 21 to 2018, urging Constable Senior to include the name of the confidential human source for the intel report, was at his direction. When asked why he gave this direction, he said that in circumstances where an informant was going to get paid, they must be identified by YRP prior to payment. This would suggest that investigators already had a plan in place to provide Constable Senior with money to pay the informant in order to see what he would do with it. A clear integrity test, which is, again, not what you're allowed, that's one of the things you're not really allowed to do with entrapment. It is clear that, initially, there was no reasonable suspicion in relation to Constable Senior uttering forged documents of any kind, and certainly not specifically relating to intelligence reports. When this commenced, Constable Senior simply wanted to report the criminal behavior of Sherry Wafer and her family. It is not clear to this court what, if any, reasonable suspicion that wish to report created. However, it certainly became an objective. In fact, it became an objective to the point of UC1 telling Constable Senior to start the intel report. While this court acknowledges that reasonable suspicion is not an unduly onerous standard, it must be focused, precise, reasonable, and based in objective facts. It is the view of this court that the threshold for reasonable suspicion was not met when UC1 made that comment. Even if reasonable suspicion did exist prior to opportunity, this court finds that this went beyond opportunity to inducement. So remember those two different ways that you can get to entrapment is, providing an opportunity to somebody where there's no reasonable suspicion, the sort of virtue testing aspect, and also the inducing somebody who you might have reasonable suspicion, but, pushing them into it, where they, where you're pressuring somebody to do something they don't want to do. So an average person in the position of Constable Senior would have been induced into uttering the forged document. UC1 admitted that he knew Constable Senior was the source of the information and did not want his involvement known. With this knowledge, UC1 suggested that he had a few ideas to insulate him. UC1 specifically directed Constable Senior towards using the YRP 050A intelligence report form designed for confidential human source information. While Constable Senior certainly initiated the idea of reporting this information, this court does not accept that he picked the form to use. On August 16, 2018, after spending some time with UC1 drafting the intel report, Constable Senior explicitly asked if he needed to put a name on the report where it said confidential human source, and UC1 said no. Constable Senior turned to UC1 for guidance on how to proceed with the report. When Constable Senior demonstrated hesitation, UC1 encouraged him to move forward. When the report was submitted, there was no name. There were then a series of emails in which Detective Sergeant Bedford, at the direction of Detective Sergeant Salia, urged Senior to provide a name. Having considered the entirety of the circumstances, this court is of the view that there was no reasonable suspicion when the opportunity was first presented, and that there was inducement for Constable Senior to falsely attribute the name to a confidential human source, David Broadhead, on the form. This offense was the work of the state. Count 2, uttering a forged document, is stayed. So that's it. That count is gone, and it's because they found that that this undercover officer was willing to essentially manufacture a crime. They lured Constable Senior into this trap and then pressured him to the point where either he had to say, hey, listen, I screwed up. You know, I submitted this, form, in which case, do you think they would have let him off the hook on that one? I don't think so. I mean, they would have said, hey, why'd you submit this fake form? Or he had to, come up with his name, which, yeah, and it was quite intentional that they put him into this really bad, bad scenario. If you think about, if a friend did this to you, how upset would you be with that friend? Like, you'd never talk to that person again. This is some serious betrayal going on here. Constable Senior, so analysis and conclusion in relation to theft, because he was charged with theft for keeping the $300. So they say Constable Senior kept the $300 intended for David Broadhead that belonged to the police, knowing that he had no lawful claim to it. He took that money in order to cover up the fact that he had falsely attributed the information on the intelligence report to David Broadhead, because of course that was part of their goals there, is that once you get him to give a fake name, now they can insist that this fake name has to get paid, and so they can put money into Constable Senior's hands and see what he does with it. Because, now they're upping the stakes, right? So given Constable Senior's behavior and comments, he most certainly knew that he had no right to the money. Upon accepting the money, he stated that he would get someone else to sign off, which was exactly what he did, and then dispose of the cash. It is important to note that Constable Senior never raised the notion of paying confidential human sources for information. In other words, he showed no interest in extracting such money from the police in order to have it for his own benefit. There was no evidence that Constable Senior had ever handled confidential human source payments in the past, apart from the transaction with Undercover 2 on August 25th, 2018, which itself was a pure integrity test. So that was a previous interaction with, this Henry Wong figure, where they sent him in with money to pay this informant, and the informant is like, this is an insulting amount of money. This is, I make this in 10 minutes, screw off. And, refuses to take the money and basically pushes it back. And eventually, I think, if I recall correctly, actually puts, essentially gives it back to Constable Senior, which is why Constable Senior was ultimately acquitted on that one. So, it's really kind of interesting here because, if you think about it, if you're just providing information to the police, usually you don't get paid, usually. But here they're really keen to make sure everyone's getting some money on this one. I wasn't aware that the police force was so well funded that they can just be giving money away for people who never asked for it. That's interesting. As a taxpayer, I'd like to think that maybe they should be a little more frugal with their dollars. But Constable Senior had never dealt with this. He might not have seen that this is weird. I would have probably been saying, hey, buddy never asked for money. How come you got money to just throw away here? But taxpayers' dollars, that's what it is. So Detective Sergeant, well, it's more that they want to snare him, but I'm just being cheeky. So Detective Sergeant Salia testified that the monetary payments were the usual consideration for source information, and that the objective in relation to having the intelligence report completed was for the informant who was the source of the information to be paid. He later clarified that another objective was an integrity test to find out whom Constable Senior was attributing the information in the intelligence report. It is the view of this court that the evidence clearly establishes that investigators knew from the outset that there was no confidential human source and that the information was coming from Constable Senior. This was abundantly clear to UC1. Constable Senior never suggested otherwise. He was very upfront with UC1 about the fact that he, Constable Senior, was the source of this information about Sherry Wafer and her family. Constable Senior also made it very clear to UC1 that he did not wish to disclose that he was the source of the information. However, knowing that Constable Senior was the source, and that there was, therefore, no source to be paid, Detective Sergeant Salia still directed that the money be provided to Constable Senior to see what he would do when faced with this scenario. When Constable Senior was provided with the payments, one for Henry and one for the sherry wafer source, he had a very candid conversation with UC1 as to what he should do with the money. He was told, do whatever you want with the cash. I don't effing care. UC1 then suggested that Constable Senior put his own signature on the payment form and said, I don't fucking know. So, even by this time in September 2018, there was no reasonable suspicion that Constable Senior was committing the offense of theft under $5,000. The interaction between UC2 and Constable Senior on August 25th, 2018 was itself an integrity test and not based on reasonable suspicion. Detective Sergeant Salia testified that the objective of the first payment to Henry was an integrity test to see if Constable Senior would keep the money or return it to the police. He further testified that direction was given to UC2 to refuse the payment and try to see if Constable Senior would query a plate for him instead. On August 25th, 2018, Constable Senior presented UC2 with $1,000 in payment money. Henry signed the receipt, took the money, and had it in his possession for a period of time before putting it back on the table twice and telling Constable Senior to take it. This court concluded that Constable Senior would have believed that the owner of the money at this point was Henry, not the police, because of course he's being, they're running an undercover here. Notwithstanding the fact that Henry is the police, like he is a police officer, he thinks this is an organized crime guy who's now giving him $1,000. I mean, should he be taking $1,000 from an organized crime guy? I would say no, but it's they've deceived him into thinking that's what's going on, and that wouldn't be theft. It would be, potentially some other crime. So given the information that Constable Senior had, this court was left in reasonable doubt as to Constable Senior's intent at the relevant time, and Constable Senior was found not guilty of theft as it related to this interaction. This court is unable to derive reasonable suspicion from this interaction. If you didn't commit a crime in that interaction, you can't use it to get reasonable suspicion. The Crown submitted that after Constable Senior uttered the false intelligence report, the investigators had the requisite reasonable suspicion that Constable Senior would conduct himself in the same dishonest fashion with respect to the cash, and that the offenses were rationally connected, proportional, and temporally connected to the grounds established by the false intelligence report. It is the view of this court that no such rational connection existed between the submission of the false report and theft. Further, any reasonable suspicion gained by the submission of the false intelligence report cannot be relied upon given the earlier findings of this court that this itself amounted to an inducement where no reasonable suspicion existed. Even if this court were to conclude that reasonable suspicion existed, this went beyond opportunity to inducement. So it is the view of this court that this was a pure integrity test which also amounted to inducement. Count 1, theft, is also stayed. So that one also goes away. Now let's consider a bit of an alternative possibility here. Let's say, because here it was very clear that they wanted to put this money into his hands to see what he would do with it and to see if he would commit a crime, and by keeping the money. And so they said, hey, listen, let's make sure it happens. But Senior never actually asks for the money. He doesn't ask for it. It's actually a pain in his butt. It causes him more trouble than, I suspect most people would not, it's, he wouldn't have wanted this hassle for $300. It was just a new annoyance in his life, a new thing that he had to figure out how to deal with. So, but, if we consider the alternative hypothetical, let's say they say, okay, you put a name down, and then Constable Senior himself says, well, shouldn't that dude get paid? Where's the money? Like, I'll take him the money. Come on, let's make this happen. Then we would probably not be looking at entrapment, and we'd be looking at him getting convicted on that. So that, and that makes sense, right? If he's initiating committing a crime, it's a very different scenario than if they're putting money in his hands in the hopes that he's going to. We should theoretically not be in this situation where they're trying to trick us into crimes. Even if you're working for the police, that seems unfair. All right, carrying on. So analysis and conclusion in relation to uttering forged document, this being the payment form. So again, with the same situation with the informant, they're sending this money. He's got to get a receipt on this. So how does he do that? Well, he gets somebody to forge it. Let's see what the court says about this. So this court found that there was more than ample evidence to support the fact that Mr. Wills was being asked to forge David Broadhead's signature on the payment form. Constable Senior and UC1 had clearly prepared the intelligence report with information provided by Constable Senior, and to a lesser extent with information recovered from police databases and social media. With respect to the payment, Constable Senior and UC1 debated what to do with the cash, knowing that there was no confidential human source, but rather Constable Senior was the source of the information. Ultimately, Constable Senior stated that he would get someone to sign off, which was exactly what he did. The intercepted communication between Mr. Wills and Constable Senior established, beyond any reasonable doubt, that Constable Senior asked Mr. Wills to forge Mr. Broadhead's signature. Constable Senior was most certainly aware that Mr. Wills was forging the signature. He explicitly asked him to do it. After inducing Constable Senior to commit the offense of uttering a forged document, the investigative team went one step further and introduced the $300 payment for the source of the intelligence report. Again, Constable Senior turned to UC1 about what to do with the money and was told, do whatever you want with the cash, I don't fucking care. UC1 then suggested that Constable Senior put his own signature on the payment form and said, I don't fucking know. Nobody's going to take that suggestion seriously, right? That's obviously kind of a joking suggestion. Detective Sergeant Salia explained that monetary payments were the usual consideration for source information, and that the thought process in directing Constable Senior to fill in the paperwork in relation to the intelligence report was that an informant must be identified prior to payment, so as to complete the process and payment. The paperwork had to be filled out correctly in order to identify who would be getting paid as per procedure. Now, again, I wonder just how often they actually make monetary payments, because I suspect they get lots of information without ever getting paid. Lots of people call up and say, hey, you know what? This house next to me, I'm pretty sure they're dealing drugs out of it, and never see a dollar. But this time, they're real keen on making sure people get paid. So as previously stated, the evidence clearly established that investigators knew from the outset that there was no confidential human source and that the information was coming from Constable Senior. This payment and related payment form was completely an integrity test. Again, things might have also been different if they weren't conducting this full-on, undercover operation here, and that it just happened that Constable Senior came up with this himself, and that, then unaware that this was Constable Senior's plan, that they said, oh, well, you got to make sure this guy gets paid. That, again, might not have fallen into the same entrapment issue. The Crown submitted that ascertaining how Constable Senior would deal with the documentation of this payment was both, one, necessary to maintain consistency with the broader undercover investigation, and two, a natural and reasonable investigative response to the false intelligence report that Constable Senior had just submitted. The Crown argued that, after Constable Senior submitted the false forms attributing confidential human source information to David Broadhead, the investigators had a reasonable suspicion, and that it would be reasonable to suspect that Constable Senior would conduct himself in the same dishonest fashion with respect to the confidential human source payment form for David Broadhead. Therefore, according to the Crown, investigators permissibly provided him with the opportunity to commit this related offense, which was rationally connected to the grounds established by his submission of the false intelligence report. Now, I might agree with the Crown here if it wasn't for the fact that that first, false report was something that they created, that was their artifice. And so, hey, we did a bad entrapment thing, and then that bad entrapment thing worked, and because of that, that gave us some additional suspicion that he might do this other thing that we've now led him into. Yeah, I got some issues with that, but I mean, the Crown wouldn't have known that the court would already have rejected that previous one. Certainly the Crown would have had a very different position on how they should have handled those previous issues. So, as previously stated, any reasonable suspicion gained by the submission of the false intelligence report cannot be relied upon given the earlier findings of this court that this was done without reasonable suspicion and amounted to an inducement. So the court is saying, hey, listen, that was entrapment, so you can't chain your entrapments and eventually it becomes good. Although, spoiler alert, maybe that's not the case. Let's keep going. It would be completely unfair to base future reasonable suspicions on actions this court has determined to be offensive to the principles of decency and fair play. It is impossible to separate these events, as one leads directly from the other. While it is true that Constable Senior, seemingly of his own initiative, approached Fabian Wills to forge his signature on the payment form and then submitted that form, this was only after a series of events that induced him to submit the related intelligence report in the first place. It is also true that Constable Senior was aware, by this point, that a confidential human source payment could be refused and returned. As stated earlier, Constable Senior's failure to make the right choice does not excuse the actions of investigators and is not the focus of an entrapment application. Count 3, uttering forged document in terms of the payment form, also stayed. So far he's doing real good. 3 for 3. Let's see if that keeps going. Because we haven't gotten to the big stuff yet. And when you think about where the court is going to be most willing to stay charges, do you think it's the big stuff or the little stuff? Yeah. So unauthorized use of computer database and breach of trust, counts 4 and 5. Constable Senior was convicted of both of these counts in relation to Henry Wong only. Constable Senior ran a license plate at the request of Henry Wong, who he believed to be associated to organized crime, and provided the results to him. Constable Senior was well aware of who Henry was purported to be and what he intended to do with this information, which is to engage in locker rips. Now, in the summary that I cut, they noted that they were trying to portray Henry Wong, they say, as this non-violent drug figure, that he's going to rip off these lockers, but he would never use violence, which is super implausible, right? I mean, if you think about organized crime, there's not a lot of organized crime where violence isn't at least on the menu. There are no outlaw biker gangs that threaten to come by and plant flowers in your front yard. They might threaten to plant you in the front yard and use you to fertilize those flowers, but not, So, like, when I feel like the court kind of has it both ways here, because, when we're talking about who Henry Wong is, purported to be and what he intends to do with this information, it's bad stuff, right? And people can get killed when organized crime goes and does bad stuff. Being on the receiving end of a ripoff like that is a dangerous thing. People get killed, that way. So, yeah. Skipping ahead through a whole lot of stuff. Again, all of this stuff is from the previous videos if you want to see it, because I can't make this thing 6 hours. Everybody would be just asleep or sending me hate mail. So analysis and conclusion in relation to unauthorized use of computer and breach of trust. Constable Senior accessed a computer database to run the license plate number for Henry. The YRP directives are clear that such activity is prohibited. Henry's purpose for wanting this information was crystal clear. He directly states it. Constable Senior knew that Henry wanted this information to rip drugs from a rival drug dealer. Henry said this explicitly to Constable Senior several times. The only assurance Constable Senior received that no violence would be used in this rip, or even that a rip was the real reason behind the request for this address, as opposed to something more nefarious, came from Henry, a purported drug dealer whom Constable Senior had only known for 2 months. Constable Senior knew that he was putting his neck on the line, to use his own words. That's always bad when they're using your own words against you. Never a great place. Constable Senior's knowledge is further demonstrated by his comments that he would have to get this done off radar and to get someone to backdoor channel it. Now, I mean, in other places, they're going to be commenting about how Henry says that he's, such a non-violent figure, and that Constable Senior should not feel threatened or intimidated or anything like that. But, here the court seems to suggest that Constable Senior should know that maybe Henry's planning to murder some people. When they say something more nefarious, like he's running a plate, clearly that's a possibility, is that Henry might not be just wanting to know who this person is to track down a drug locker. They might actually want to just kill that person whose plate they're running. So, I don't feel that this is one that you can have both ways. And I don't think that there's a way to get around this, when you are pretending that somebody is an organized crime figure, that should be taken as inherently coming with it the threat of death or serious bodily harm. Yeah, you don't just you don't just annoy organized crime figures. You risk your safety in doing so. So, yeah, I feel like this as a tactic should be taken as inherently something that includes some risk of, threat being communicated. We see this also in like Mr. Big stings where they're like, oh, well, Mr. Big, this, fake organized crime figure never explicitly threatens them. Like, yeah, but it's kind of implicit. Like we've all seen movies. We have all seen, we've all seen in the news about, these criminal organizations getting into battles with each other and people dying. So, yeah, got some concerns. So, as for the breach of trust, Constable Senior was certainly an official acting in connection with the duties of his office. He was a police officer interacting with a person he believed to be his confidential human source. It is true that, by the time of this request, Henry had built a rapport with Constable Senior. A relationship of trust had developed. Constable Senior may well have believed that the future of their working relationship would be affected if this information was not provided. However, this was not the message being conveyed by Henry. Of course, do you have to say these things explicitly? Not usually, right? If Constable Senior came to this conclusion, he did so without prompting from anyone. Again, yeah. Constable Senior clearly knew it was wrong to provide this information to Henry. He tried many times to get Henry to consider other means of obtaining this information. Constable Senior, for whatever reason, may well have believed that getting this information for Henry would further his relationship with Henry, thereby furthering his career in law enforcement. However, he also knew that it was wrong. As a public official, a police officer, Constable Senior was not at liberty to use any means necessary to further his work with a confidential source and to further his career, including breaking the law, and he knew that. Reasonable suspicion was clearly present as it related to these offenses. Detective Sergeant Salia characterized this as the core investigative objective of both undercover officers. And this was, right? They wanted to see, will he provide this information to, some organized crime figure? And yes, in the context of, trying to get more information. I mean, you could argue as to whether or not this is something in the greater good, but that's a real tenuous argument and gets weird. So this objective was directly linked to the suspicion investigators had reasonably developed that Constable Senior was conducting unlawful queries and disclosing information from those queries to people in his life. As early as April 20th, 2018, investigators had the requisite reasonable suspicion, as a result of the CPIC audit and other investigative efforts, to suspect that he had improperly queried and disclosed confidential information at the behest of friends, associates, and persons associated with organized crime, who seemed to be his friends and associates, which, again, super weird for a cop, right? I mean, cops shouldn't be hanging out with criminals, you'd think, but that was never really taken as... You'd think that would have been enough to just fire him, but they didn't do that. That's weird. That's concerning, York Regional Police. That's super concerning. Just saying. Because you know what? If I, as a gun owner, was hanging out with organized crime figures, they'd come for my gun license. They would say, hey, listen, you can't be associating with these figures. We want your firearms license. But apparently not applying to the cops. So I don't know how to reconcile this with how the universe ought to work, other than just to say this seems super broken. It was absolutely reasonable for investigators to seek to ascertain whether Constable Senior would conduct this query and disclose this information at the request of UC2, so the Henry Wong figure. The applicant conceded that, earlier in this investigation, a reasonable suspicion existed that Constable Senior was committing the offenses of breach of trust and unauthorized use of a computer. Therefore, the focus in relation to these counts was on the second branch of the MAC test, inducement. So basically, on this one, the defense is saying, listen, you got reasonable suspicion. We can't argue that one. However, even with that, it's still entrapment because they pressured him into it. They forced him into it. So the applicant argued that even though there was reasonable suspicion as it related to this criminal activity, the police induced the commission of the offenses. This court does not agree. So it looks like Mr. Senior's streak is coming to an end. The crimes being investigated were serious. there was a reasonable suspicion that Constable Senior was querying police databases at the behest of organized crime figures and sharing that information. The average person in Constable Senior's circumstances would not have been induced to provide a mid-level organized crime figure with confidential police information to facilitate a drug rip of his rival in order to further develop a professional relationship with a confidential informer. The disclosure of this information was completely contrary to police policy, was intended to facilitate the commission of a serious criminal offense, and raised obvious public safety concerns. Again, public safety concerns, but Senior's not threatened. Interesting. Frankly, this would be common sense and would not require training in relation to handling confidential informants to understand. I kind of feel like that's a fair comment. I mean, you do have to consider that maybe you're going to get somebody killed if you are providing this information. The encouragement Constable Senior received from superiors for his work with UC2 was documented in emails from Detective Sergeant Bedford and amounted to nothing more than a pat on the back. There were no hints or promises of promotion. I mean, come on. If you're constantly getting pats on the back from your superiors, that kind of suggests that there's, good stuff coming your way. Nor were there any explicit or implicit threats of professional or personal consequences to Constable Senior should the flow of information end. I kind of feel like that's also inherently there, right? It's, they say it is likely that sometimes such relationships do end despite best efforts. But you don't, do you not think that there's going to be some inquiry on that? Like, if you are working at a company and you're in sales, and, you have this interaction with a really good customer, somebody who's bringing in millions of dollars for your company, they're a really good customer. And then one day you go for a lunch meeting with them, and immediately after the lunch meeting, they call up and say, you know what, we've decided to go with a competitor. Bye, click. Sales relationships end despite best efforts sometimes. Maybe the competitors came up and said, you know what, we're going to make you such a smoking deal that nobody else is going to be able to compete with it. But do you not think they're going to have some meetings about that lunch meeting that you had? Like, you're going to have to explain yourself? I think that would be expected. I think that would be normal, that they'd be going, hey, what happened? And even if it ended despite your best efforts, you might still get fired. So, when they say there's no explicit or implicit threats of professional or personal consequences, I don't know that I agree with the judge's logic here. I mean, these are findings of fact, so they're going to be very difficult to overturn on an appeal. I don't like it. I disagree with some of these conclusions about how the universe works. It is true that UC2 made a few attempts to have Constable Senior query the plate before it actually occurred. Persistence does not necessarily equate with inducement. It is the view of this court that the applicant has mischaracterized UC2's evidence in suggesting that there was an implicit threat to their ongoing relationship, and by extension to Constable Senior's career if this information was not provided. UC2 testified that he was attempting to convey the exact opposite, in that he did not want Constable Senior to do anything that would compromise him. He said that in the intercepts, UC2 made it clear that this request was separate from the information he'd been providing the police, adding, I got something else lined up for you guys. The reality is that Constable Senior and Henry had only been working together for a short time. Henry was basically a stranger. No threats were made, explicitly or implicitly, and the stimulation was purposely designed to convey nonviolence. You just said that that he should have known that there was a public safety concern. You just said that that he should have known that this could have gotten people hurt. That there might have been something more nefarious going on. How do you reconcile that this is purposely designed to convey nonviolence, and yet Constable Senior should have known that violence could have been a potential consequence? Ugh. Again, not something that's going to be able to be overturned on appeal, but it's frustrating to read this. I disagree in very strong terms with the logical analysis here, because it seems to me that they're trying to have things in two ways that are mutually inconsistent. Pick a lane. Either Henry Wong is the kindest, gentlest organized crime boss ever to step foot on the planet, or there's implicitly some violent threat to things. You gotta pick one. You know, yeah. If a guy shows up, and I know he's involved in organized crime and he shows up on my doorstep and says, "Hey, I don't want you to think I'm here to kill you or hurt you." I think he's there to kill or hurt me. In some circumstances as well, somebody assuring you that they are not there to engage in violence might actually convey the opposite. Hey, I just decided to come to your house and tell you, I don't want to hurt you. It's like, oh, I didn't know that was on the table. About that. So yeah, anyway, let's keep going. I could go on this rant. There is no question that Constable Senior was made to believe that his relationship with UC2 was a positive one and was leading to positive results for police. In fact, they told him that repeatedly. However, the encouragement he got from Detective Sergeant Bedford was nothing more than mild praise for his work with his informant generally. There was certainly no suggestion that he should do everything, lawful or otherwise, to maintain this relationship. I mean, that's fair. Clearly, UC1 conveyed to Constable Senior that he was not prepared to run this plate. So that was when Constable Senior asked his partner if he could run the plate for him instead. At most, UC1 appeared to suggest to Constable Senior that this was his confidential informant, and he would have to judge for himself what he should and should not do. While UC1 did provide Constable Senior with some advice and guidance on working with confidential informants, as did Detective Sergeant Bedford in an email, there was no suggestion made that he should commit acts contrary to law or policy to maintain that relationship at all costs. In fact, quite the opposite. This court is not satisfied on a balance of probabilities that the police went beyond providing Constable Senior with an opportunity to commit the offenses of breach of trust, an unauthorized use of a computer, and induced the commission of the offense. There will be a conviction on counts 4 and 5. So Constable Senior is at least on the hook on 2 counts, and yeah, that's not good for him. And now we're getting to the main show. Drug warehouse. Count 6, possession of a firearm obtained by crime. Count 7, weapons dangerous. Count 9, trafficking cocaine by officer. So all the stuff up till now is the small stuff, but we kind of need to look at it in terms of looking at the context. How does this happen? How do we get to this point? Because, I mean, this is kind of a showstopper, right? This is like Hollywood TV stuff. So let's keep going. As previously stated, Constable Senior was alleged to have planned and progressed past mere preparation to rob a drug warehouse that Henry Wong had advised him about, in which he anticipated that there would be several kilograms of cocaine and cash. In preparation for this robbery, Constable Senior was alleged to have stolen and placed a loaded police shotgun in the back of a rental van. Further, Constable Senior was alleged to have offered to traffic the cocaine he expected to find in the warehouse to George Paputzos, Michael Vigliotti, and Henry Wong. Michael Vigliotti is aka Lips. That's a real interesting nickname. Constable Senior was found guilty of count 6 and 7, possessing a firearm obtained by crime, and possession of a firearm or weapon for purposes dangerous to the public peace. He was found not guilty of count 8, attempted robbery, because they said he hadn't gone far enough along to have begun an attempt. And he was found guilty of count 9, which is trafficking the cocaine by offer. He's not actually providing any cocaine, but he's offering to do so, which is itself a crime, but only as it related to George Paputzos and to Henry. All right, so there's a few things here. They say it was never an objective of the investigation to implicate Constable Senior in any sort of robbery or to involve the use of firearms in any way. As an objective in relation to trafficking cocaine, this did become an objective in mid-September 2018. So this, they say, is something that sort of happened by accident. It wasn't a goal, it was just a thing that kind of happened. And yeah. Now, this happens, substantially later in this whole operation. This is after that they've already sort of been talking about how he wants to, run this plate in order to be able to rip the stash. That happens August 30th. And, Constable Senior wasn't being suggested as being involved in this. But they keep telling him about how much cash has been seized, how much... So they've been providing him with these big numbers in terms of how much cash and cocaine are in each of these lockers. These are not like, hey, we found, you know, the amount that somebody might do at a party. This is, hey, we're finding kilograms and thousands of dollars of, in terms of cash. So lots of money there. So eventually, Constable Senior starts talking about how, maybe he could get this stuff, and so Detective Sergeant Salia testified that this was a significant, unexpected development that caught him off guard. Prior to this, there'd been no suspicion or objective in relation to trafficking cocaine. I mean, hey, all they'd been doing is just talking about just how much money is there. And UC1, his partner, had been talking about things like, oh, I got a pair of snips. We can go, kind of suggesting that they could go do this themselves. So no suspicion or objective, but it's kind of seems like maybe they were fishing on that. All right, carrying on here. So skipping along a little bit here. So this is a portion of the wiretaps here, UC1. But I want to know what this fucking warehouse is all about. I want to know. And Senior says, no, you just do paperwork. See the paperwork. There's paperwork. Little paperworking ass, it's fine. But apparently he said warehouses. UC1, where are all these fucking lockers? They're all over the city. UC1, I was just sitting there thinking, you know what I mean? There's a lot of cash coming out of those fucking places. And Senior says, a lot. Well, it is what it is, brother. We're just the intel guys. We don't do the doors. We don't get hands-on. UC1 says, why not? And Senior says, it is what it is. And UC1, his partner, says, why not? I don't see why not. Don't see he's been fucking legit, right? He's fucking Chinese organized crime or whatever. So it might be so, but he hasn't fucking steered us wrong, and it's been bang on, time sensitive. It's fucking solid shit, man. So he's already going, why not? Why don't we do this? So UC1 testified that he was suggesting they execute the warrant on this warehouse themselves. I don't see how that makes sense. I mean, how? Like, these warrants, when the warrant goes out, the police force decides who's going to go do it. It's not like they can just, it's not like you can just be like, oh, I'm going to go do it. Like it's, a posted quest in a video game where just anybody can just take it down off the wall and just go run it. And they're like, oh, hey, good stuff. No, it's going to get assigned to somebody. So I think that seems sketchy to me. This was not an investigative objective or something he had planned. It was his attempt to steer the conversation away from Constable Senior's request that he run the plate. Constable Senior's response confirmed that he shared UC1's interpretation of their conversation, in that he referred to them being the intel guys, and that they don't do the door, don't get hands-on. The following exchange then occurred. So UC1, that warehouse, we got to talk about that too. And Senior says, brother, he says, I'm not doing lock. You still missing it? You still missing the heroin dude with the gun? Hey, slow down. Yeah, we'll do that, but I'm looking at a big score, so fuck it. Eh? Looking at if it's a big score at a warehouse, you know what I mean? And Senior says something unintelligible, and then, yeah, but I don't think it's anytime soon. He said he's working on it. It'll be a couple of weeks, unintelligible. And UC1 says, well, yeah, if it's that much of a warehouse, is that much fucking dope, I don't care about the dope cash and stuff. Why don't we just I got a pair of fucking snips. You know where I'm going with that. Senior says, he laughs and says, okay, that's fine, but focus for a second, okay? We still have the heroin dude to deal with. So, yeah, oh yeah, they're just planning on executing a warrant here with his pair of snips. So by this point, UC1 was in his car and Constable Senior came back to his window when he spoke to him. UC1 testified that the reference to snips was not part of his planned objective. It was just in conversation. He stated that he was trying to squirm out of running the license plate. Also, he was trying to allude to some nefarious nature, to his criminal element and how he was interested in money. And he's kind of suggesting a specific criminal offense here, isn't he? In cross-examination, UC1 agreed that he saw this as an opportunity to add to his cover story and suggested executing a warrant themselves and something nefarious underlying that. UC1 agreed that there had been no suggestion to him by anyone that Constable Senior had been taking money from lockers or snipping lockers. So that's a new thing. And that's, again, relevant in terms of, whether or not they had reasonable suspicion with respect to this kind of crime. Okay, again, skipping over a whole bunch of stuff, but looking at some of the wiretaps here. And I'm looking at more wiretaps at this stage because this is kind of the big event, right? So, all right, what do you want to do with what's his face, Henry's warehouse? I don't know. He hasn't told me anything about it. UC1 says when it comes up, if it's fucking drugs, guns, and cash. Senior says, I don't know. What do you want to do? UC1, I don't know. Senior says, you want to make some money? You want to? And UC1 says, fuck yeah. And he laughs. What do you think? Senior says, you want to make some money or what? Undercover 1 says, oh fuck, why not? And Senior says, well, here's what I'm thinking. My logic is here. I say we tell what's his face, like he tells us where it is. We have his guys knock it. We take the cash and he takes the product and done. So UC1 says, have his guys knock it? Senior, yeah. How much is it? I don't know. I don't know anything about it. I know nothing about it. And so UC1 says, no, in the previous. Senior says, it varies, right? From what I can remember from the warehouses, one was, UC1 says, it's all on the emails. So pointing him back to those emails where they said, hey, here's how much, loot was in these things. UC1 said, why are we going to let them knock it? Why don't we fucking... See, there's a little hint there. And Senior sighs. UC1 says, well, the only problem is the other shit. Like, I got no reason. I got nothing to do with fucking... And Senior says, yeah, that's what I'm saying. So it's... And UC1 says, burners and fucking... Unless you want it. And Senior says, well, no, because I have nowhere to go to. So this is what I'm saying. I'm saying if we do a combination knock, his guys take the product and go, we take the cash and go. And UC1 says, yeah, then we're his guys. That was my fucking thing. Why can't we bring our own fucking, like, we need somebody to keep 6. So UC1 is making a further suggestion. Not, do a combination knock. We'll do it just, why can't we do our own thing? Senior says, that's what I'm saying. So if we have 2, and UC1 says, I don't fucking want it. That's what I'm saying. So unless you want it, I don't fucking want it. I have nothing to do with it. So my point is, he says, so my point is if these guys come and take it, then these guys come and take it and go. I don't want to carry it and drop it off. So when they say they don't want it, they don't want to hold on to cocaine because, they're cops and that would be a real, it's a lot easier to explain having cash than it is to explain having cocaine. UC1 says, no, I ain't fucking transporting for no one. Senior, that's what I'm saying. So have him come and cash and carry it himself. Okay, either him or no, he will. And this is kind of how these intercept transcripts come out, because when you're having a conversation, people don't sort of have nice dialogued conversations. They have interruptions, they have stops and starts and, all sorts of things. So that's part of trying to, reconstruct this. So UC1 says, they're not going to leave the cash. Senior says, huh? UC1, they're not going to leave cash. Senior says, that's what I'm saying. So UC1 sniffs, and Mr. Senior says, so you, me, and Bob takes, and then we'll take the cash. I'm thinking, like, I know a couple of guys, but my problem with, I know one guy, he's like, no amounts, no nothing. He's fine, and he'll just take the product run. And UC1 says, yeah? Senior says, he'll take the product, yeah. And UC1 says, that's perfect. He says, he'll take the product. So UC1 says, if he did. And Senior says, the only reason why I wanted Henry involved is because then his hands got blood on it too, get me? And UC1 says, his hands already have fucking blood on everything. And Richard Senior says, I know, but I'm saying it's his hands with blood on it. Like, he can't say X, Y, or Z because you're culpable as you're an accessory, right? So they're having some discussion about this, but you can see UC1's sort of involvement on that and his discussions. So it was on September 17th, 2018 that Detective Sergeant Salia became aware of the discussions between UC1 and Constable Senior regarding robbing the warehouse. When he learned of this plan, Detective Sergeant Salia directed UC1 to continue to explore and entertain this dialogue to determine its veracity and whether it was seriously contemplated by Constable Senior. According to Detective Sergeant Salia, it would have been neglectful as police officers to dismiss the utterances made by Constable Senior. He directed UC1 to continue to build rapport and to explore the robbery scenario, including identifying co-conspirators, and to not decline should Constable Senior suggest including any potential co-conspirators in the operational plan. I guess, they want to see if they can, track down more people. So I'm skipping ahead a bit to the analysis and conclusion with regards to these charges. And they start off with reasonable suspicion and opportunity, because that's the first part of the test that we were looking at, right? So prior to September 12, 2018, there was no reasonable suspicion of Constable Senior in relation to break, enter, and theft or robbery type offenses. There were no objectives in this regard. Things changed significantly on September 12, 2018. It is the view of this court that the mention of snips by UC1 on September 12, 2018 was a suggestion that they should do a break, enter, and theft of the warehouse. There is no other possible way to interpret the comments in context. This suggestion clearly came from UC1, not from Constable Senior. The Crown submitted that UC1's intention was to convey that they should execute the warrant themselves, which this court finds hard to accept on the plain meaning of the words and considering the discussion as a whole. Certainly, UC1 meant to convey a nefarious meaning by his words and by asking Constable Senior if he knew what he meant. Constable Senior clearly knew what he meant by the discussion that followed. Yeah, he's trying to suggest that he's this sort of criminal, shady guy, so it's not, we're going to execute the warrant. How does that make any sense? You can't just pick who's going to execute the warrant. It's not like, this isn't like who gets the first donut in the break room. So the applicant submitted that the first opportunity to commit the offenses that followed, counts 6, 7, and 9, occurred on September 12, 2018, when UC1 told Constable Senior that he had a pair of snips and implied that he would be interested in seizing cash from the warehouse himself. The next opportunity was on September 17, 2018, when UC1, after complaining about his money problems, asked Constable Senior what he wanted to do about the warehouse, the information from UC2. So, I got money problems. Hey, about that warehouse that I'd already talked about, snip, snip. The applicant submitted that, in that same conversation, UC1 suggested to Constable Senior that they should rob the warehouse themselves, and the opportunities escalated on September 18, 2018, when UC1 suggested to Constable Senior that he had robbed warehouse like this in the past, and that on those occasions they had gone in heavy. The applicant argued that, after the initial conversation planning the robbery on September 17, 2018, UC1 was consistently directed by Detective Sergeant Salia to discuss the robbery with Constable Senior. After that day, every conversation between UC1 and Constable Senior constituted yet another opportunity created by the police for Constable Senior to commit the robbery in general, and thus the offenses of possession of a firearm obtained by crime, theft, weapons dangerous, and trafficking cocaine. The applicant argued that UC1 manufactured the idea to use a firearm during the robbery, the idea to steal the shotgun from a police cruiser, and the idea to bring a third party or parties to whom they could traffic cocaine. The court is not in agreement with these suggestions, so this does not look good for Mr. Senior. It is accepted by this court that UC1 was alluding to some sort of criminal activity, such as break, enter, and theft, when he referred to having snips. However, it is the view of this court that the comment of having a pair of snips does not amount to an opportunity. Not every police action will amount to providing an opportunity to commit an offense. For example, as stated in Ahmad, in a conversation, an opportunity will be established when an affirmative response to the question posed by the officer could satisfy the material elements of an offense. UC1 asked no question. It is the view of this court that this comment was nothing more than an investigative step to further his cover story. Constable Senior does not even bite on the suggestion made by UC1. I feel like this might be a little bit narrow of an interpretation, but yeah. Even if this court were to conclude that this comment amounted to an opportunity, this comment was certainly not an opportunity for a robbery. At its highest, this comment could not be taken as anything more than break, enter, and theft. There is absolutely no suggestion of violence in the comment. There was certainly no suggestion of firearms being used. There was no suggestion of trafficking any product that may be found inside the warehouse. Contrary to the applicant's submissions, the suggestion of involving firearms and trafficking product comes directly from Constable Senior. This kind of grates on me because, as we've already talked about, a lot of this stuff involves the potential for violence. If you are going to rob a drug house, you got to be aware that it might not be as easy as a break and enter and theft because there might be a guard posted. This is Breaking and entering into somebody's house creates the risk that you might end up in a confrontation with that person. That is part of the sort of logic on sentencing and on viewing a break and enter into an occupied home as a very serious thing. Certainly, criminal enterprises where they have a warehouse full of drugs are highly likely to have somebody guarding it. So, suggesting that you're going to go in and snip things and that you might go in heavy, I mean, I think that that sort of assumes the possibility that you might get into conflict with it. And, in terms of the suggestion of trafficking any product that might be found in the warehouse, I mean, what else are you going to do with it? You're going to leave it behind? That seems weird. Or are they just going to keep the cocaine as like a sentimental kilogram of cocaine? Something that you've got fond memories of? Like, this is my favorite brick of cocaine. Uh, this this seems weird to me. Yeah. I mean, the justice has clearly been very careful in their thinking here, but there's places where I'm just like, you gotta pick a lane. You gotta decide which thing it is. So anyway, skipping over a lot of the chronology here. Again, I covered this in detail in previous videos, and I don't want this to be 8 hours. So carrying on here, the entire circumstances, including this brief chronology of facts, make it abundantly clear that the idea of introducing firearms and the idea of offloading the cocaine came directly from Constable Senior. While this court does not accept that Constable Senior raised the idea of breaking into the warehouse, he led the discussion of whether they should go in armed, whether they should take from the station, whether they should take shotguns or ARs, and how they could obtain firearms without detection. Contrary to the applicant's submissions, UC1 never expressed experience in breaking into or robbing warehouses. The experience was in executing warrants. The many conversations between UC1 and Constable Senior do not show Constable Senior presenting as deferential to UC1 as submitted by the applicant. Constable Senior often led the discussion and regularly presented ideas. Independent of the investigative team, Constable Senior located and stole a shotgun that his colleague had left behind in a police vehicle. Now, I guess the question is, would any of this discussion have happened absent this suggestion of breaking into this place? It's hard to say, but I kind of think no. Constable Senior also led the discussion regarding what to do with the product they found inside. He independently initiated conversations sufficient to establish the elements of cocaine trafficking by offer. Contrary to the applicant's submission, there is no reason to believe that UC2, that Henry Wong, cover story of being involved in the importation of drugs from China, was purposeful to lead Constable Senior to this criminal activity. And, I mean, I kind of agree with this, because, I mean, Henry Wong, if he's supposed to be some criminal, mid-level criminal figure, he's got to be doing some kind of crime, right? I mean, there's got to be something he's involved in. So importing drugs makes sense. There is no reason to believe that this was an objective of this investigation until September 10th, 2018, when Constable Senior, on his own initiative, asked Henry Wong whether he'd be interested in selling product to his friend George, clearly referring to cocaine. Detective Sergeant Salia testified that this was a significant, unexpected development that caught him off guard. Prior to this, there had been no thought of investigating Constable Senior in relation to trafficking cocaine. This conversation between Constable Senior and Henry Wong alone was sufficient to establish the suspicion that Constable Senior was involved in trafficking serious drugs. This court does not accept that Henry Wong's cover story was a setup from the beginning, but rather was related to the suspicion that Constable Senior was conducting improper queries and sharing that information with suspected organized crime associates. Further, it is not reasonable to suggest that the information into steroids was related to taking Constable Senior down this path. The suspicion in relation to steroids came together when the list was discovered on Constable Senior's phone, especially when viewed in the context of other evidence. As for UC1's suggestion that the third party was necessary, this suggestion was in relation to a person keeping 6. It was Constable Senior's suggestion that Lips would be a good candidate to take the product and move it. Now, I mean, we've already said, oh, well, there's no suggestion that UC1 was suggesting, violence. Well, the keeping 6 kind of suggests that, that's a concern there. I mean, that keeping 6 in terms of what that usually means is somebody watching your back in a fashion that is more than just a lookout, more than just a let us know if the cops are rolling up. That usually suggests somebody who is, armed and, you know, covering your back, somebody who's going to be able to, defeat threats to, or so. He, I've already kind of ranted on that. I'll keep going. With respect to the weapons offenses and trafficking by offer, it is the view of this court that, considering the totality of the circumstances, Constable Senior created his own opportunities. Even if this court were to accept there were no reasonable suspicion in relation to trafficking cocaine, due to the suggested uncertainty of the conversation between Constable Senior and UC2, it is the view of this court that it was Constable Senior that suggested offloading the product for money. And inducement. The applicant, so this is, if they did have reasonable suspicion, did they push him into it? So the applicant further submitted that even if reasonable suspicion existed in relation to these offenses, the police went beyond opportunity to inducement. This court does not agree. That's a real bad sign for Mr. Senior. The crimes being investigated by this point were very serious indeed. The police had formed reasonable and probable grounds to arrest Constable Senior for the offenses of breach of trust and unauthorized use of a computer. They were planning a takedown. There was reasonable suspicion that Constable Senior was trafficking in steroids. There was reasonable suspicion that Constable Senior was trafficking in cocaine. As a result of the discussions that had taken place and were continuing, investigators were attempting to determine the seriousness of Constable Senior's willingness to participate in a robbery. This was serious. An average person in the position of Constable Senior would not have been induced into the commission of these offenses. While it is true that Constable Senior and UC1 had developed what appeared to be a very good partnership and a rapport by this time, the intercepts demonstrate that this was a very equal partnership. I mean, most friendships are, right? I mean, do you think that UC1 could have gotten this far if he was coming off like a bully or, domineering? Yeah. This court does not accept that Constable Senior was manipulating into believing this was something UC1 did all the time. UC1 never suggested a history of breaking into or robbing warehouses. His experience appeared to be in executing warrants. Except they've already made the suggestion that the Snips was talking about warrants and that it wasn't, and, trying to present him as nefarious. I don't have the full facts here. It just seems strange, but this is not a place where I can really criticize because I wasn't there at the trial, so I don't know. There were many lengthy conversations between September 12th and October 9th about the warehouse plan and other issues. Given how the conversations developed, it makes perfect sense that UC1 will be given the daily objective of discussing this topic. On some occasions, it was UC1 that initiated the topic of the warehouse. However, having carefully reviewed the intercepts in their entirety, Constable Senior and UC1 were certainly evenly matched in the conversations, both of them making suggestions and disagreeing with the other's suggestions. UC1 offered Constable Senior opportunities to exit the plan, offers that were denied. This court does not agree that it was implicit that a firearm would be needed and that a third party would be needed to offload the product. Going in heavy was a topic raised by Constable Senior. Taking a shotgun from the station was a topic raised by Constable Senior. Taking the shotgun that had been left in the Tahoe was a topic raised by Constable Senior. Trafficking the drugs from the warehouse was a topic raised by Constable Senior. This court does not accept that Constable Senior was induced into these offenses by UC1 using his position as a mentor or friend. As previously stated, the conversations about the operational plan involving the warehouse showed both men equally participating in the conversation, often in a lighthearted way. There was no suggestion in the evidence that Constable Senior was being pressured to do this. There was certainly no evidence upon which to conclude that he was being pressured to do this by his friend who was having financial problems, as the applicant suggested. It is the view of this court that there has been no inducement. So, conclusion. With respect to counts 6, 7, and 9, no entrapment has been established. Convictions will be entered on those counts. So, Constable Senior is in a real bad place because those are some pretty serious charges. I can tell you from reading other news articles, apparently his defense counsel is suggesting something less than 5 years. So probably just a little bit less than 5 years. Crown is seeking 12 years. And from this, I think my bet is that the ultimate sentence is going to land somewhere closer to the Crown's position than it is to the defense's position. We'll see how this ultimately shakes out, but that's that's kind of my wager on this one. Trafficking steroids to UC1. The facts in relation to this transaction were not in any real dispute. So this is a steroid trafficking issue where another colleague was, and UC1 both wanted steroids, but this one is talking specifically about his partner. So UC1 asked Constable Senior to assist him in getting $400 worth of steroids. Constable Senior had discussions with Mr. Paputzos about what he could buy for $400. Constable Senior collected $400 from UC1, delivered that money to Mr. Paputzos, and transported and delivered the steroids from Mr. Paputzos to UC1. The text messages between Mr. Paputzos and Constable Senior, the name of George that was written on the Ziploc bag containing the drugs, and the name George on the text message in relation to steroid dosages shown to UC1, established that Mr. Paputzos was the supplier of the steroids. The Health Canada certificates established that all three substances were anabolic steroids under Schedule 4 of the Controlled Drugs and Substances Act. As for Constable Senior's role, he alone chose the seller. He discussed with the seller the products that could be purchased for this amount of money. Constable Senior set up this transaction with a person and at a location unknown to the purchaser. Constable Senior made it possible for a sale to occur that could not otherwise have taken place. In addition to the transaction that occurred with George Paputzos, Constable Senior was also negotiating with Henry for the purchase and sale of bulk steroids to UC1. So, skipping over a whole bunch of that, we're going to jump straight to the analysis there. The applicant submitted that there was no reasonable suspicion that Constable Senior was committing the particular offense of trafficking steroids, as opposed to possession of steroids, prior to the YRP providing with several opportunities to do so from July 23rd onward. The applicant submitted that trafficking steroids was not the only reasonable inference available from the evidence, specifically from the list found on Constable Senior's phone in the folder titled Sherry L, in conjunction with the intercepted coded conversation. It is the view of this court that reasonable suspicion most certainly existed. Remember how they discussed reasonable suspicion more than a hunch, and while they're required to consider contradictory evidence, they're not required to do further investigations on that. So while Detective Sergeant Salia agreed in cross-examination that it was possible, based on his physical observations of Constable Senior, that Constable Senior was using steroids himself, he still expressed confidence in his suspicion that Constable Senior was trafficking steroids based on this evidence. Detective Sergeant Salia stated that it was of no moment whether Constable Senior was the author of the list, and in fact took the position that Constable Senior was likely not the author. It is true that police suspicion that Constable Senior was in personal possession of steroids or used steroids would likely not justify the police providing him with an opportunity to commit the more serious offense of trafficking. However, the evidence went beyond mere possession in this case. And this is from stuff I cut and was covered in some previous videos, but there was a burner phone, there was some discussion of, basically a list of debts. There was some coded conversations that they intercepted about is the ice cream in the freezer, and that they later sort of decoded to determine that was a reference to steroids. So all of these kinds of things. So it arose from the screenshots of the list of steroids, complete with quantities and pricing, located in the secreted Sherry L folder stored on Constable Senior's phone, which gave an earlier intercepted coded conversation between Constable Senior and Ms. Wafer greater significance. Accordingly, the first time UC1 mentioned his interest in obtaining steroids was on July 27th, after the investigators developed this suspicion. Both Detective Sergeant Salia and UC1 testified that investigating Constable Senior for steroid trafficking had not previously been an objective of the investigation. So they expanded that because of, this information that they found. The applicant submitted that even if Salia had a reasonable suspicion that Constable Senior was trafficking steroids, Constable Senior's consistent discouragement of UC1, even entertaining the idea of steroid use between July 23rd and August 27th, should have dismantled any reasonable suspicion that could have existed. This court does not agree with this characterization of the evidence. The fact of the matter is that UC1 never specifically asked Constable Senior to get him steroids before Constable Senior offered on August 27th to ask Henry about getting him some Chinese gear. Prior to that, they had one conversation and some text messages about supplements, diet, and workout, and on 2 occasions, UC1 stated an interest in using steroids. On August 30th, Constable Senior asked Henry if he could get steroids for UC1, after only a compliment on his physique, which was specifically intended to provoke that response. That was noted as part of their objectives on that. So, in terms of this, when we're talking about, all of this, UC1 basically goes, hey, I'm considering using steroids. And he goes, no, you should, have a protein shake. You should work out more. You should do these things, which kind of seems strange, if you're a drug dealer. Like if you're in the business of, selling cocaine and somebody you trust asks if they, asks about cocaine, wouldn't your response normally be, yeah, I can hook you up? Or even just, yeah, I know a guy, just to, test the waters. But he doesn't do that. He shuts them down. While it is true that UC1 initiated conversation with Constable Senior about fitness, exercise, and ultimately steroid use, it is the view of this court that these conversations do not amount to opportunity. As previously stated, UC1 had never expressly asked Constable Senior to obtain steroids for him before Constable Senior offered to speak to Henry. Further, UC2 being directed to raise the issue of steroids on August 30th does not amount to opportunity. Frankly, it may have been perfectly acceptable for UC2 to raise this subject, but the fact is it was Constable Senior who actually raised the topic of steroids, because they were hinting about it without actually saying anything directly. The applicant further submitted that if this court were to find that reasonable suspicion existed, the police went beyond creating the opportunity to traffic steroids and induced the commission of the offense. This court does not agree. The intervention from the team was perfectly consistent with the level of seriousness of the crime being investigated. An average person in the position of Constable Senior would not have been induced into the commission of trafficking steroids. Steroids specifically had only been raised by UC1 on 2 occasions before Constable Senior offered to speak to Henry, which he did. To suggest that this amounted to persistent importuning does not accord with the evidence. After Constable Senior made the offer to speak to Henry and did speak to Henry, this developed into other conversations which resulted in Constable Senior obtaining steroids from George Paputzos while still negotiating for something larger with Henry. This court does not accept that Constable Senior was pressured or even motivated to do this as a result of having developed a deep personal relationship with his partner. As stated above, this court does not agree with the applicant's portrayal of this relationship. Frankly, the two had no significant personal relationship outside of work, other than all of those other things that you noted that they were doing together outside of work. Their professional relationship had only existed for 2 months when Constable Senior offered to speak to Henry, and only slightly longer when the steroids were obtained. And I mean, it's going to be a little harder for Constable Senior on this one because he was also getting steroids, apparently, for Timur Turmurberlatov. So this one's a little bit of a tougher sell. When looking at the totality of the circumstances, it is obvious that the discussions unfolded naturally and without undue pressure. When Undercover 1 demonstrated that he was committed to bettering his lifestyle, Constable Senior generously offered his assistance and advice and ultimately arranged the purchase and delivery of steroids from his friend George Paputzos. The intercepted conversations established that Constable Senior was very familiar with different kinds of steroids and how they should or should not be used. Neither UC1's requests nor UC2's compliments induced him to commit this offense of trafficking steroids. There was no entrapment, therefore a conviction will be entered on count 12. And this is, again, a serious charge, so Constable Senior, on balance, is not doing well here. I mean, he could have been doing worse. He's got some stays of proceedings, but all the really big, nasty stuff, the stuff you really worry about, still on the table. And as mentioned, Crown is seeking 12 years. That's a fair chunk of time. I know that my American viewers will probably be saying, wait, 12 years, that's it? And, I mean, Canada typically has much lower sentencing regimes than the US. We've got a strong belief in rehabilitation, and so that's a big sentence here by Canadian standards. And for all like 10 of you who've had the attention span to make it this far, I know that Canadian standards is going to end up being a meme in the comments. I'm here for it, so go nuts. I'm just curious to see what you'll come up with. Let's carry on here with residual discretion, abuse of process, Section 7 and 24.1 of the Charter of Rights and Freedoms. So Section 7 is life, liberty, and security of the person. So that's what that section guarantees. 24.1 is a provision that allows for the court to award remedies. So 24.2 of the Charter is where the court can exclude evidence. and 24(1) is for all other remedies that the court might impose, which has been found to include things like potentially monetary awards, although that doesn't seem like it's going to come up here. Stays of proceedings are the big one. That's what they're asking for here, is a stay of proceedings. But it's also been held to include things like sentence reductions. There's all sorts of potential for remedies under 24(1). It's basically a catch-all for, what do we have to do to fix this? You can do it. That's what 24(1) is for. All right, carrying on here. Supreme Court of Canada has recognized the residual discretion of a court to enter a stay of proceedings due to an abuse of process. The Supreme Court has said that such cases generally fall into two categories. So first, where the state conduct compromises trial fairness, the main category. And second, where the state conduct creates no threat to trial fairness, but risks undermining the integrity of the judicial process, the residual category. So if we want to think of things that might compromise trial fairness, let's say they threaten one of your witnesses. They say, hey, if you testify for the defense, we're going to have you deported. That might, compromise trial fairness. Or let's say that they go and destroy evidence. Somebody else gives a confession and they, that person, so that's a recorded confession, and the government says, yeah, that'd be real inconvenient, so we're just going to feed that into the shredder. That would be an example of state conduct that compromises trial fairness. But there's also things that might, undermine the integrity of the judicial process in terms of if they've treated you badly or something like that. Behaviors that the government might engage in that might not make it an unfair trial, but where we might be saying that we're unwilling to have this happen in a society that is ostensibly a free and democratic society. So the test for determining whether a stay of proceedings is warranted is the same for both categories and consists of three requirements. So first, there must be prejudice to the accused's right to a fair trial or the integrity of the justice system that will be manifested, perpetuated, or aggravated through the conduct of the trial or by its outcome. So that's sort of a complicated thing. They're going to discuss it a little bit further. There must be no alternative remedy capable of redressing the prejudice. So as I said before, a stay of proceedings is kind of the remedy of last resort, because in general, we want to say, hey, we're going to have a trial. We're going to, hear this out. And so if there's some other remedy that we can use that will still guarantee a fair trial, we'll go with that instead. So that might be, for instance, excluding a witness or excluding some evidence. It might be, an adjournment in order to fix things, a new trial, these kinds of things. If any of those things can solve it, we're going to do something else other than a stay of proceedings. So that means that a stay of proceedings is pretty hard to get, right? Because it's got to be the only possible answer to it. And where there's still uncertainty over whether a stay is warranted after steps 1 and 2, the court is required to balance the interests in favor of granting a stay, such as denouncing misconduct and preserving the integrity of the justice system, against the interest that society has in having a final decision on the merits. So, and this is a complicated question, because we generally say that society has an interest in having a decision on the merits, but sometimes the state conduct might be so egregious that it's a real problem. If we're talking about, when I was saying earlier, no threat to trial fairness, but risks undermining the integrity of the judicial process. Let's say that we've got a guy who's been arrested. He goes in, he talks to the police, he gives a full confession, no problem. He just spills everything. He's not very bright, but, and so in terms of trial fairness, all of the evidence is already in, but the police just really dislike this guy. Maybe, he did something to the police. Maybe he was, persistently breaking into cop cars and crapping in them or something, where the police really dislike this guy. So after he gives the full confession, they take him out back behind the station and they put the boots to him for a half hour. And, trial fairness, well, you don't need any evidence. He didn't say anything while he was having the boots put to him. It's not a trial fairness kind of issue, but it's still egregious conduct. And if the court doesn't impose some sort of remedy there, then really what we're saying effectively is that that's okay, that this is, not going to have any effect on it. So that might be an example of a situation where the court might want to grant a stay of proceedings. I mean, it's a pretty extreme example, but it illustrates the point. All right, carrying on here, there's a whole lot of discussion, and this video is already real long. So I'm going to give an example here from one decision, and this is one that made the news. It's the case of the Queen and Nuttall. The British Columbia Court of Appeal upheld the trial judge's independent ruling on abuse of process after ruling on entrapment. In this case, the accused were charged with terrorism offenses to be perpetrated upon the Parliament buildings in Victoria on Canada Day in 2013. The Court of Appeal found that the trial judge made errors in the application of the legal principles of entrapment through a subjective analysis of the accused's beliefs instead of an objective analysis of the police conduct, and therefore the finding of entrapment on the basis of a lack of reasonable suspicion was unfounded. However, the court found that the entrapment based upon the conduct of the police in the undercover operation, amounting to an abusive process, was unassailable. Now, this is a case which, if you don't remember it, this one made a whole lot of news because basically they found these two idiots and they essentially they thought that these two might commit an act of terrorism, or they hoped that they might in some fashion. And so they wanted them, they were trying to sort of walk them through this plan. But at every stage, these idiots were just completely useless. They'd be like, hey, here's some money, go buy some stuff to make it, make bombs. And they'd take the money and they'd go smoke meth. And they just couldn't get these guys to be, able to conduct terrorism because they were such useless people. They were just not. And so the police basically had to hold their hand through this entire terrorist plot that they also had to come up with themselves. And so at the end of the day, the court is like, okay, yeah, you got them to maybe start on doing a terrorism, but you had to do all the work. Like, they just kind of were there. So yeah, that was that was why that decision got struck down. So they say, on the other hand, the police do not have a free hand to do whatever they wish in order to investigate crime, even serious crime. The concepts of fairness and justice are still highly relevant, and police conduct undertaken in the investigation of crime must be balanced against them. However, in this case, the police actually knew Mr. Nuttall and Ms. Cordy had little to no ability to commit an act of terrorism. Certainly, they were right to commence the investigation, and certainly they had reasonable suspicion that the two might commit a crime. However, as found by the trial judge, the police went far beyond investigating a crime. They pushed and pushed and pushed the two defendants to come up with a workable plan. The police did everything necessary to facilitate the plan. I can find no fault with the trial judge's conclusion that the police manufactured the crime that was committed and were the primary actors in its commission. Although in some cases the police may have to be the primary actor when all of the circumstances are considered, assessed, and weighed, the misconduct of the police in this case far outweighed their violation of the concepts of fairness and justice. I therefore agree with the trial judge that the overall conduct of this investigation was a travesty of justice. This is not to suggest that Mr. Nuttall and Ms. Cordy are harmless. They may be very dangerous. However, that danger was not apparent in the investigation, which was confirmed by Sergeant Kay's continually telling his superiors that they presented no imminent danger or risk. There was no danger because Mr. Nuttall and Ms. Cordy neither had the means nor the ability to carry out any of the plans without substantial aid from the police. And I mean, really, the police shouldn't be helping terrorism. I feel like that's a thing. And so they also look at the case of the Queen and Dada, and they affirm that entrapment falls into the residual category. They say it was the applicant's position that the police conduct in this case and this is back to the present case, was a travesty of justice. The applicant argued that the resources devoted to specifically investigating Constable Senior were jarring when considering the initial objectives, an investigation into breach of trust and unauthorized use of a computer. The applicant pointed to the following. So prior to the deployment of the undercover officers, the Project Godot investigation involved 6 investigators working full-time to comb through many years of Constable Senior's queries, duty notebooks, GPS data in police cruisers, etc. After the initial Part 6 wiretap authorization for Project Godot on June 14, 2018, the investigative team grew considerably as they required several civilian monitors to transcribe the intercepted communication and sworn officers to analyze the communications and make decisions in real time. Later authorizations granted the police access to Constable Senior's phone records, text messages, etc., all of which required more resources to review and analyze. The process of selecting both Undercover 1 and Undercover 2, beginning around the end of May 2018, required examining a pool of potential candidates and identifying a suitable officer for the operation, with the appropriate background and expertise to take on the tasks. Both UC1 and UC2 had their own handlers who were responsible for communicating objectives, monitoring the progress of the undercover operations, supporting them through the process, and served as a means of isolating the undercover operators from the larger investigation. After the deployment of UC1 and UC2, Detective Sergeant Salia described the investigation as a complex or robust undercover operation. Particularly for UC1, the deployment was more than a full-time job. UC1 worked during the day undercover as a uniformed officer next to Constable Senior, doing traffic enforcement and other duties, and he would often have to engage in evening deployment scenarios. All the while, UC1 was expected to fulfill his duties as an officer for the Organized Crime Enforcement Bureau. In addition to this exaggerated use of resources, the applicant submitted that this course must consider the incessant rapport building, infiltration, and persistent importuning directed at Constable Senior over a period of approximately 4 months. The applicant analogized this case to the situation in Nuttall, suggesting that it amounted to a multifaceted manipulation designed to exploit Constable Senior's deepest insecurities. The applicant submitted that the decision to have UC1, another racialized officer with a questionable professional history with the police, act as Constable Senior's partner was not random, and that the issue of systemic racism was a live issue within the police. Further, the applicant argued that the timing of the deployment of each undercover officer was particularly suspect. Despite UC2's deployment having been contemplated first, UC1 was deployed a full 2 weeks before the confidential human source scenario began and given the objective to build rapport. The applicant submitted that with this context in mind, directing UC1 to use positive and negative reinforcement, ask for and give favors, both personal and professional, discuss their personal lives, financial woes, opinions on police corruption, all before UC2 was even introduced, was clearly designed to set the stage for UC1 eventually escalating his behavior to the point of inducement. It is the view of this court that, in considering the complete context of this investigation, this case does not even come close to warranting a stay of proceedings for abuse of process. The following context is crucial. So they say, first, the police began investigating Constable Senior in February 2018 as a result of allegations made by a confidential informant that he was involved in corrupt practices. 2, there was a systematic investigation of the allegations made by various audits and legitimate investigative tools, including surveillance, a detailed CPIC audit, and various judicial authorizations, including warrants and intercepts. Investigators isolated approximately 150 queries that were deemed suspicious, in that they appeared to be conducted in relation to friends and family or related to persons believed to be associated to organized crime. Next, investigators formed reasonable grounds to believe that Constable Senior had committed the offenses of unauthorized use of computer and breach of trust. There was deep concern that organized crime figures had infiltrated the York Regional Police. This concern arose as early as April 5th, 2018. Yeah, that is a worry. That's a concern. In an effort to determine the scope of this conduct, investigators employed the use of undercover officers who developed rapport and relationships with Constable Senior. Rapport building is a common and appropriate technique. The timing of involvement for each of the undercover officers causes this court no concern. They played very different roles in the investigation, one being the daily eyes and ears, the other being more directly involved in the scenario to see if Constable Senior would run a plate at his request. Now, I mean, if the guy is just supposed to be eyes and ears, they've already got recording devices in the vehicle. So in terms of the eyes and ears aspect, like, why do they need an actual dude who can feed him in this information, which the court has already found that some of it was, in fact, entrapment, but not all of it. So UC1 was to work alongside Constable Senior while the scenario with UC2 was unfolding. His objectives were to monitor Constable Senior and develop a rapport with him. The involvement of these undercover officers was reasonable and necessary to satisfy the objectives. There is no reason to believe that UC1 was deployed in order to increase pressure on Constable Senior to have him commit crimes he would not otherwise commit. And they also specifically address the systemic racism argument, saying there's absolutely no evidence that systemic racism played any role in how the investigation unfolded or in Constable Senior's decisions. It is unfortunate that such a serious accusation would be suggested where no evidence exists. So the court doesn't like that one. The resources placed on this investigation were appropriate in the circumstances. The concern that organized crime figures may have infiltrated the organization would be of utmost concern. Investigators must be allowed to make their own decisions regarding required resources. Fair enough, right? The court isn't supposed to be second-guessing how every investigation takes place. but there's limits on that, right? So the court, looking at this case in hindsight, is not in the best position to fairly judge how many resources should have been expended. Again, fair enough. We're, Saturday morning quarterbacking this thing. So the question is, at the time, did they know what was going on? Because, if you think that this is a really serious infiltration, lots of money might be justified. And then later you find out, if it's just one dude, then you go, oh, well, I guess we didn't need to spend that much money. Problem is that once you've spent that much money, you really want to get something big and showy for it, don't you? You don't want to say, hey, at the end of the day, we caught this guy fixing traffic tickets. That's really hard to justify on the budget at the end of the day, right? It looks way better if you get something big and... All right, this might be a little conspiratorial. I'll move on. The rapport developed between the undercover officers and Constable Senior was completely reasonable and expected. As previously stated, the relationships were fairly brief and focused on the tasks at hand. It is true that Constable Senior and UC1 discussed some personal topics over this time. However, the suggestion that Constable Senior was manipulated does not accord with the many hours of intercepts that this court has reviewed very carefully. Constable Senior presented as a strong-minded, independent thinker. The picture that the applicant has attempted to paint of Constable Senior as a weak, unknowing, vulnerable prey is simply not made out on this record. This court has accepted that some of the conduct of the police stepped over the line. However, these are fine distinctions to draw in any case. Police investigators are tasked with making minute-by-minute decisions as to what the next investigative steps should be in the circumstances. While Detective Sergeant Salia was directing this overall project, UC1 and UC2 had to make decisions as the conversations unfolded. There was often no time for consideration and reflection in many instances. It is the view of this court that this investigation was well managed and carried out for the most part. It certainly does not amount to the type of conduct which would warrant a finding of abusive process and lead to a stay. Project Teddo was a good faith, thorough investigation into suspected police corruption. The object of the investigation was very serious, concern that organized crime had infiltrated YRP through a corrupt officer. In my view, a stay in relation to certain counts is warranted for the reasons stated above. However, a more generalized stay for abusive process, considering the factors in Babos, is absolutely not warranted in the circumstances. Such a stay would bring the administration of justice into disrepute. So, conclusion, they find as follows. So they stay count 1, they stay count 2, they stay count 3. So that's the theft, the uttering forged documents, and another uttering forged documents. Again, those are the small fry on this one. But count 5, breach of trust. Count 6, possession of firearm obtained by crime. 7, possession of weapons for purpose dangerous. 9, trafficking cocaine. And 12, trafficking steroids to the undercover officer. All of those are convictions on that one. And count 13, the unauthorized use of computer, was not really the focus on this one because it wasn't connected to the entrapment argument. This was not an entrapment argument on this one. And so they noted that it's not part of that, but they're not... If there was a general stay of proceedings for abusive process, it might have been caught up, but they're not doing that, so a conviction on that. And a conviction on count 14, which was another breach of trust that wasn't part of the entrapment application. So, 158 pages of entrapment law and specific details on that. So, I got it down as much as I could here in terms of timing. Hopefully, all of this made sense. Now, I want to just talk a little bit more about entrapment and about kind of the rationale for it. Because, there is this notion that the police shouldn't be engaging in random virtue testing. But one thing that I think the court didn't really consider and kind of worries me as a prospect is, let's think about just how much money they spent on this guy, right? This is an operation involving a whole lot of very well-trained individuals. These are basically secret agents. And, millions of dollars and huge amounts of surveillance put on this guy, all to the eventual end of seeing if they can get him to commit some crimes. And they actually specifically push to try to get him to, the court found that they not only, offered him opportunities that they shouldn't, but that they actually, that they went so far as to pressure him into those. So the concern isn't just, kind of, is the government going to randomly virtue test you? But also the question I have, the thing I worry about is just how many people could stand up to this if you spent millions of dollars to try to corrupt somebody? They already knew that having a police officer meet with the undercover or meet with this organized crime figure, meet with the confidential informant on their own is dangerous. They knew that that's part of how you end up corrupting a police officer, which is why they have protocols set up to prevent that. And so, in the course of all of this, we see the officer becoming corrupted. And the question is, if none of this had happened, would he have taken those steps? And I mean, the other question is, like, if you had millions of dollars and direct surveillance and an undercover placed with somebody, could you not convince, like, the average fast food worker or road worker or, you know, Uber driver or whoever into committing crimes and into theoretically joining some fictional, um, you know, fictional crime organization and eventually coming up with their own ideas? And I mean, the court seems to have said, listen, eventually he starts coming up with his own ideas, so he's at fault for that. But was that process of him coming up with his own ideas, could that have been the result of a dedicated corruption effort that they aimed at this guy? I mean, here's the problem that we have here is that some of this appears to be like pre-existing stuff. Like, they certainly had some suspicion that he was involved in stuff before they got to him. And I mean, there are some queries that are weird, and there's some indication of steroid stuff and so forth, and various connections to organized, like, how was this guy a cop in the first place? And how many other cops out there are just like him for all of this stuff that they didn't seem to be too bothered by? But, I mean, all of us are fallible to some extent. Most people are going to have a difficult time resisting this kind of concentrated effort and this kind of all-encompassing thing where they can effectively take over your life. And, for a while, it seems like everything that Constable Senior was hearing in terms of when he gets praise at work, it's part of this operation. When he gets, when his partner responds to him, it's part of this operation. When his partner doesn't respond to him, it's part of this operation. I kind of feel like if I had this budget and this level of resourcing and so forth, that I could probably corrupt a fairly large amount of the population. I think that in most cases, the reason why lots of people aren't involved in, sort of bad stuff is nobody's ever going to spend millions of dollars to try to convince you to do something bad. I mean, frankly, if I had, $2 million or whatever this investigation cost, I'm sure it was not cheap. And you said, hey, can you go convince this, this guy, working at McDonald's to, deal some drugs? I mean, it'd probably just go to the guy and be like, here's $50,000, go deal some drugs. And they'd probably be okay with it. That would actually be considered entrapment. But if instead of spending the $50,000, you go and, subvert the guy's friends and his workplace and all of this and create this elaborate scenario where you're constantly hinting at stuff, just a little bit hinting at it, I kind of feel like that's, an issue. And so part of the reason why we have these rules is not just, out of a notion of fairness, but I think it's also out of a notion that we need protection from the government, because sometimes governments and police and so forth, they're mostly made up of people who have good intentions, but good intentions can lead us to do bad things. And, sometimes we've seen that. There have been far too many examples of wrongful convictions, for instance, where police officers who thought they were doing the right thing massaged a case into existence that didn't exist otherwise. or, concealed evidence or something along those lines that didn't fit with it. These provisions are really intended largely to protect us from the government and from these kinds of abuses. We shouldn't have to live with the scenario that, from 1984 or other things, of a government that is going to shape our world around us to pressure us into stuff. Essentially, as a law-abiding citizen, government should leave me alone and should leave me alone to continue being law-abiding rather than saying, I am sure I'm a nuisance to several government figures because some of them have actually gone so far as to put it in writing that, that they consider me a nuisance or a problem. I like to think that it is not within their realm, within their toolbox, to decide that because I'm a problem, they're going to try to ensnare me in some fashion. And, the government shouldn't run honeypots against its own citizens just for no reason. Or even, even if they think you're a bad person, they should have a real high test on this. So this case makes me uncomfortable. And it makes me uncomfortable partially because Constable Senior is not super sympathetic. I mean, we talk a big game about the government shouldn't go after, even the unsympathetic person in terms of, tripping somebody up on recovery and so forth. There's all sorts of, I think that they had plenty of reason to just fire him. And I would have been entirely okay if they just fired Constable Senior way early on in this. Hey, we got a report from a confidential source that says you are, sharing information with bad dudes. We pulled all your stuff and we did an audit. And there's a whole bunch of stuff here that we just can't explain. Bye. I'd be okay with that. And so I mused about this before, although I don't know if it was in part that I cut, but it can be really hard to fire a police officer. So I wonder how much of this also relates to just, we can't fire this guy, even though we have all these suspicions that he's a real bad dude. We can't just fire him or that's not going to stick. So how far do we have to get this guy before we can actually make him not a cop anymore? Anyway, I'm just kind of musing. This is a really messed up case. It's a really weird Hollywood story kind of case. It would not surprise me if this ended up being sort of pirated or cribbed for an episode of some, lurid TV show somewhere, of this cop. But I am very conflicted about this one. Yeah. Anyway, this may be the last episode on Senior because, this is the big entrapment decision, or I may end up covering his sentencing because, as I noted, there is substantial difference between what the Crown wants, 12 years, and what the defense wants, which is somewhere less than 5. I'm guessing not a whole lot less than 5. I'm guessing they probably said 5 years adjusted for time he's already done in custody. That's my guess, although I don't know. So I may end up covering that just to see what the court does with the fact that this is a police officer being sentenced on some really big stuff. It also wouldn't surprise me if there's an appeal on this one. I don't see a whole lot of room for an appeal, but I do see some. I think that some of the analysis is inconsistent, and I think that there should have been more consideration. At least this is my read on it. I would have liked to see more consideration about the cumulative effect as to, we've agreed that we've got him on entrapment on some early stuff. And there's kind of this thing about once you get the ball rolling and once you get somebody doing small things and you've already got them ensnared, it's a lot easier at that point to push them to do bigger things. I mean, this is how people get flipped, is you get them moving on small stuff and then you get them onto big stuff. This is a tactic for police in interrogations, is they'll get you talking and, they'll get you talking about your job and about the weather and so forth. And once you're already talking, it's hard to stop. So I would have liked to see more analysis about that sort of cumulative effect and whether the big charges weren't the result of the steady push from even, for going back to the smaller stuff that the court was willing to find the entrapment on. Yeah, I mean, ultimately, everybody got something out of this one. It is kind of a split the baby decision. Senior isn't, he's justified in saying that he was entrapped on some of the offenses, but not on all of them. So anyway, controversial as heck, I'm sure. There's lots of room for discussion on this one. Let me know in the comments what you think. I've sort of laid out my thoughts here. I'm still really torn on this one. I think I'll also say, I think the lawyers did a good job. There's places where both Crown and defense get criticized by the courts. That's normal. Judges, in fact, one of the worst things is when you walk into a courtroom and you've just run a trial and the judge can't stop saying nice things about you. Because when the judge is talking, and saying, oh, well, whichever side made really able submissions and they did really well, you're pretty sure that side's going to lose because the court is sort of talking you up and saying how well you did just before they drop the hammer on you. So it's really normal that both sides have said some things that the court doesn't agree with. There's no places in here. In some of my other videos, I've commented about how you'll see the judge kind of, backhand, criticizing or, saying something fairly harsh about one side. The justice really doesn't do any of that here, at least not that I can recall from the previous videos either. So I think everybody tried their hardest and did a really good job on a really challenging case. I mean, this is just one of those cases that's just unreal and way out there. So I want to commend the counsel on both sides on this one and the justice. I mean, I don't agree with everything that the justice said, but it's rare that you'll read a case and be like, yes, 100%. If you are a law student, this is a fantastic case to read in terms of understanding entrapment and having a good example of it. So it doesn't cover like location-based entrapment, which is its own sort of question, and I raise some issues with it, but this case really doesn't deal with that because it's a different kind of case. And 158 pages, how long do you want this thing to be? But it's still a really good primer, so it's a really good case to read. Anyway, I'm going to draw it to a close here. I have been super long-winded, but I mean, I did the other 158 pages in like 5 videos, and this one is one real long one, so yeah, hopefully it made sense. I'm kind of worried about that. Anyway, thank you for watching. Please like this video. Please share it with your friends. Subscribe to see more content. As I have noted, I try to do a mix of small videos and long videos. This is a long video. I'm going to try to do some shorter videos. There's a few people I owe a video to. One of them is with regards to this thing, the internal gun lock. So I want to get that video out soon because I owe somebody a video on that from way long ago. And yeah, thank you for watching. I also want to thank everyone supporting me on Patreon. Jonathan Wheeler, and this is at the $50 level, Jonathan Wheeler, Canada's National Firearms Association, Mike, Kyle Martin, Jean-Guy Toussaint, CCFR, and at the $30 level, Sights and Arms Limited and Marc-Olivier Demour, and then at the $20 level, Raymond Dale McKinnon, Peter Hilger, Matt Ward, Mark Whittington, Jane Babin Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you as well to everyone at the $10 level who will be in the crawl immediately following. And yeah, thank you for watching. I hope this has armed you with knowledge, and thanks for sticking with it. It's a bit of an epic saga. This is one of those cases that just, it's like a movie. That's all I can say is this is just wild. Anyway, till next time, cheers.